All right, good afternoon, everyone. This is Judge Craig McCarthy speaking. Most of us, or many of us, have been together over the long holiday weekend. It's good to see you again. Hope that all was well. As I have done, I will continue to make my determination of probable cause, and will go ahead and proceed to that unless I hear that there is a challenge. In which case, of course, I will always give each defendant the opportunity to be heard through counsel. As I mentioned, we've got a few cases we're gonna prioritize, and then we're gonna go through our Spanish interpreter cases. So I've got this in order, ma'am?
Yes.
All right, in the matter of Joel or Yoel Ami, would you state your name, please?
Joel Jr. Ami.
All right, Mr. Ami, you've got the right to remain silent here today. You've got the right to counsel. There's an attorney standing to your left. I'm appointing counsel to represent you today. We are here because there has been an allegation of, well, we've got an out-of-county warrant, number one. Thank you. And then a separate, is the battery a new charge, sir?
I'm not showing that.
That's the out-of-county, okay. So that's all I'm dealing with.
Yes.
All right. I've found the warrant to be valid. I find probable cause. I would set bond in the amount of $3,500. And while this warrant is being worked out in Osceola County, I would order no contact with the alleged victim, no return to the scene of the alleged incident, no possession of weapons, firearms, ammunition. Is there any other issue from any party? All right, that would conclude the matter. All right, in the matter of Mr. Robert Boyd?
Your Honor,
Nope.
Robert Boyd refused his,
Now, this was already reset. There's no wrong answer, counsel. Tell me how you wish to proceed on this.
We can go forward, Judge. I actually represent him on his other cases that he has in Orange County right now. So I'm
All right.
familiar with Mr. Boyd.
All right, you're appointed as to this matter. Do you have any challenges to probable cause or any other issue?
No, Your Honor.
All right. There are two counts. One is aggravated stalking, specifically cyber stalking. The other is contempt of court. I'll set bond in the amount of $500 as to count one. As to the contempt of court, bond in the amount of $100. I will include a very specific order clarifying that gentleman is not to have any contact, including via handwritten letter, no contact at all with the complaining victim. That would conclude the matter. All right, is this Mr. Pagan? All right. Mr. Pagan, would you state your name?
Louis Pagan, L-U-I-S-P-A-G-A-N, sir.
Okay. And what's your date of birth, sir?
1986.
All right, sir. Well, good afternoon. We're here because the court's received a sworn affidavit alleging several counts, sir. Are you doing all right? We've had to reset this a couple times. Are you doing all right, sir? Okay. All right. I will find, hold on now. All right, I will find probable cause. Court's inclined to set bond. We're dealing with, Madam Clerk, state, make sure that I'm getting this right. I've got 3 different case numbers I'm dealing with. Is that correct?
correct.
Yes.
All right. As to 2022 CF 14782, sir, you are accused of aggravated assault and dating violence, issuing bond, or ordering bond, rather, in the amount of $3,500. As to 2022 7126, which is a failure to appear, I will find probable cause and reduce bond to $500. As to 2022 CF 14804, alleged false imprisonment, criminal mischief, and battery dating violence, I will impose bond of $3,500 for count 1 and $500 each for counts 2 and 3. There's to be no contact with the victim in 2022 14804, no return to the scene, no possession of weapons, firearms, or ammunition. If there are no other issues, that would conclude the matter.
The aggravator sought on daily violence, same condition, with no
Yes, ma'am. Yes. Yes, yes.
return to the scene or weapon.
Yep.
Excuse me,
Yeah,
Your
I know
Honor.
there are 3 case numbers I didn't.
Excuse me, Your Honor, what was the bond amount for the false imprisonment?
False imprisonment was count 1 of 14804, $3,500.
2,000, okay. Thank you.
Yeah, then 500.
All right. All right, let's get Mr. Pagan on his way.
Thank you, Your Honor.
Be well, sir. All right, Mr. Albano? Sir, would you state your name and your date of birth, please?
Joseph Albano.
Sir, you were here for, I'll give you a second to consult with your attorney. That is your right, sir. We're here because the court has received an allegation of trespassing.
Yes, sir.
You have the right to remain silent today, all right? If this goes forward, you'll have a right to a trial. You also have the right to the assistance of counsel. You filled out an affidavit. I'm appointing an attorney to represent you. As I stated, I promised you a moment ago, I'll give you a moment to ask a question of your attorney if you need to. I will find probable cause and set bond in the amount of $500. Are there any other issues?
Your Honor, if we could inquire the state if there is an offer in this case.
Your Honor, it's my understanding that the offer in this case would be a withhold of adjudication, 5 days in the jail.
State, would you consider a $500 fine and time served?
I don't know how many trespasses. I was told that there are some people who are trespassing frequently in Wawa and that should be the sentence. But I do not know that this, for this particular defendant.
In all likelihood,
Right.
being honest with you, in all likelihood, you take your bond out, you take your time, but probably wouldn't.
Right, I would say it's the Christmas, man. You can't consider the time served 2 days, man.
Go back and forth, I feel like.
Okay, here's what we'll do. I'm going to conclude this matter. I will give the parties, and I'll leave it up to the attorneys, I'll give the parties leave to recall this gentleman. I know that, well, that complicates things in the back a little bit. So if you do come to an arrangement within the next reasonable amount of time, let me know. I can recall him. Otherwise, bond is set at $500.
No return.
No return to the scene. Thank you.
I just don't want to do it.
Alright, everybody loses their seed for holding it here. Anybody who has a seed, you're taking it for holding a man of God, just so you know.
What did I just lose? We'll talk about it later. Never mind. All right. All right, this gets us to our interpreter cases, correct? All the move-ups are done? Thank you all for, thank you for being efficient in your cooperation. We'll get the interpreter on the phone now. All right, ma'am, the reason that we're here is that I've received a sworn affidavit that alleges criminal acts, battery and battery by strangulation, and a third count of battery. You're presumed to be innocent unless it's proven otherwise, but we still need to deal with this. You have the right to remain silent today and at any time before this court. You have the right to the assistance of counsel. You've filled out a financial affidavit. I will appoint counsel to represent you. I've reviewed the affidavits and do find probable cause. My question is, I have an annotation that Ms. Jackson qualifies for pretrial release. What is the state seeking?
Judge, no objection to the pretrial release with conditions of no contact at this stage.
Anything from the defense?
No, Your Honor.
All right. I will order pretrial release. Again, Ms. Jackson, I told you earlier that you enjoy the presumption of innocence. That is true. So I don't pretend to know precisely what's accurate or what's not. I can tell you what's alleged here is more than your run-of-the-mill fight. The court takes it seriously. I hope that you do as well. So with that in mind, I'm ordering no contact with the alleged victim. Do you share a residence together? No, okay. No return to the scene, to the victim's residence. You're not, while this is pending, you're not to possess any firearms, other weapons, or ammunition. Do you understand? All right, that would conclude the matter.
Your Honor.
Is this Mr. Ward waiting? All right. You state your name, sir?
Timothy Ward,
What's your date of birth?
January 2nd, 1975.
Sir, we're here because the court's received sworn affidavit alleging possible commission of the crime of battery by strangulation as well as obstructing of justice by hindering witness communication. You are entitled to a presumption of innocence until proven otherwise. You also have the right to remain silent. You have the right to have an attorney represent you at any hearing in this matter. I do note that the affidavit that you filled out indicates that you do not qualify for an appointed attorney. What's going to happen is I will ask the Office of the Public Defender to appear on your behalf for today's purposes. They are likely to do so. But after today, you're going to either have to re-examine your financial affidavit, make sure that it's accurate, or hire an attorney of your own. Do you understand?
Yes.
Right. I've found probable cause as to both counts 1 and 2. I see a risk assessment of 0 and qualifies for pretrial release. What is the state seeking?
Your Honor, the victim is here to testify.
Oh, very good. Let's swear her in, please.
Raise your right hand. Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
Gina Pollock,
And what is your relationship to Mr. Ward?
I'm his wife.
Ma'am, typically, well, it's an imperative of the court to make sure that people are protected. It's one of the reasons that this whole procedure exists. Often, in a case like this, I will order that while we're waiting for this to resolve, while we're pending trial, that I would order that there not be contact between the defendant and the victim, and that they don't reside together. I do recognize that you are married, so I will ask you, ma'am, what would you like to see happen as the alleged victim?
I would like to not have the non-contact. I'm not afraid of him, so
You have children in the home?
no.
I mean, I did read that you have no children in common, but are there children of other relationships in the home?
No, my daughter's 25 and she doesn't live with me.
Has there been any problems with domestic violence in the past?
Yes, but
All right, can you tell me how recently?
almost 3 years ago, if I'm not mistaken.
You said 2 years?
2 or 3, something.
All right, does any Party have questions for the witness?
No, Your Honor.
Just briefly, ma'am, would you have, Mr. Ward qualifies for a program called pretrial release where he would have to check in with pretrial services in lieu of having it a post bond. Do you have any objection to that?
No.
If the record reflects she indicated no by shaking. Can you say yes or no?
You're saying that he does qualify for pre-release?
For pretrial release, it's a
Pretrial,
program
yes.
that he wouldn't have to post bond, but you'd have to check in.
Yes,
You approve of that?
I do.
Thank you. Nothing further, Judge.
I'm going to approve the pretrial release without posting bond. You and I don't know each other. We've never met. I told you before, you have the presumption of innocence. I'm hearing sworn testimony, however, that this is not the first instance of domestic violence, and maybe it's been a couple years, but at this point, I need you to understand, sir, this is no longer between you and your wife. This is between you and the court system. If I extend to you a little bit of trust, a little expectation that you'll obey the court's orders to have no hostile contact with your wife, it won't be up to her what the consequences are if you disobey my orders. Do you understand that?
Yes, Your Honor.
Spouses have all sorts of reasons to be forgiving, want things to get back to normal. I'm a human being, I understand that. But there's been a crime alleged, we're gonna deal with it. You're not to lay hands on this woman. I will allow you to return home on pretrial release. There's to be no hostile contact. I'm gonna order you to abstain from alcohol or other mind-altering substances. You're to, while this matter is pending, to have possession of no deadly weapons, firearms, or ammunition. We still understand one another?
I didn't hear the last part, Your Honor. I apologize. There was.
While this matter is pending, we all have a Second Amendment right. I'm not inquiring about that, but while this matter is pending, I'm going to order that you have possession of no firearms, other deadly weapons, or ammunition. All right. That would conclude the matter.
Thank you, Your Honor.
Is this Miss Weideman?
Yes, ma'am. Sir.
All right. Would you state your name for me, please?
Natasha Weideman.
All right. Good morning, ma'am. Or good afternoon, sorry. Ma'am, we're here because I've received an affidavit that alleges possible criminal acts, to let you know what you're facing right now. There's introduction of contraband to a county detention facility, possession of cannabis, less than 20 grams, battery, domestic violence, resisting an officer without violence, finally trespass on property after warning. I have reviewed the affidavit in this matter. As to counts 2 through 5, court finds that there's probable cause. As to count 1, the court finds that there is not probable cause based within the 4 corners of the affidavit. I'm inclined to set bond as follows. Count 2, bond of $150 for the possession of cannabis. Count 3, bond of $500 for the battery domestic violence. Counts 4 and 5, both, bond of $100 each. Did any party wish to be heard? All right.
Count one, Judge, you are.
Well, yeah, ROR on count 1, but I didn't find probable cause, so.
Okay.
All right. If there's nothing else, that would conclude the matter.
Oh, no condition. Can she come back? Can she come back right quick?
No, it's all right, it's all right, it's all right. It's all right, I'm,
She
it's
gotta
all right.
sign- Did
It's
she
okay.
sign the no contact?
I'm, on the last one, counsel, I apologize. It's the court's fault. As count, one of the counts is battery domestic violence, standard, no contact condition.
Yeah, I have to tell her.
Yeah.
wrote it.
I had assumed they'd already communicated that, which is why I said it was okay that she didn't have to come back, but I neglected, my fault, not yours, I neglected to mention, I don't know if it's true or not at this point, but there's been an allegation of battery involving domestic violence. I'm going to order no contact with that victim. Will that be a problem for you? No. All right, then we understand each other. That would conclude the matter.
Your Honor, have you considered no return on the trespass?
Yes. Yes. All right, take care.
That was my fault, Jack, I'm sorry. I'm trying to get-
Ma'am, would you state your name, please? That's you, ma'am. Would you state your name? All right, Ms. Charles, would you state your date of birth?
030596.
All right, ma'am. We're here because the court has received a sworn affidavit that alleges that a crime has occurred, that being battery with domestic violence. You have the right to be presumed innocent unless proved otherwise. You have the right to remain silent today. You also have the right to counsel. I'm appointing counsel to represent you. There's an attorney standing to your left. I have found there to be probable cause in this matter. Court's inclined to set bond in the amount of $500 and order no contact with the victim.
Your Honor, could we see if she qualifies for PTR?
We can verify.
My sheet says no, but we'll inquire.
We can verify any information. Community ties, anything.
Okay.
I see she scored 0. And also, there's the AV is back there. The alleged victim is back. She got arrested too. It's her sister. I was hoping we could get everyone out of here without posting bond. Both people were arrested.
No, I noted that. I noted that. I've not seen her sister yet, though, correct?
She indicated she can call a bond and post that bond, Judge.
So it's fine.
Okay. All right, so while, again, I told you at the beginning, you have the presumption of innocence. So the court is not certain what's happened so far. But while we're figuring that out, and this is pending, I'm going to order you and your sister to have no contact with one another. You're to maintain separate residences, but I understand that you don't reside together, so that's not a problem. And while this is pending, possession of no firearms or ammunition. $500 bond.
Yeah.
Okay,
It
that would conclude the matter.
It appears she lives in Virginia. Is it okay for her to return back to Virginia?
Say again? She's good. All right, sir, would you state your name, please?
My name is Brennan Delagarza.
What's your date of birth?
August 16th, 2004, so 08-16-204.
Sir, you're here because the court's received a sworn affidavit alleging the crime of battery. You're entitled to be presumed innocent unless proven otherwise. You're entitled to, you have the right to remain silent today. You have the right to the appointment of counsel if you cannot afford an attorney. I've seen your affidavit. I will appoint counsel to represent you. I do find probable cause. I understand this may qualify for pretrial release. Is that correct?
Yes.
Is the state seeking anything other than pretrial release?
No, Your Honor, pretrial release would be acceptable along with no contact.
Do you and the victim reside together, sir? Do you live together?
We were, but she's going back to California, I think in 2 days. But she's staying at a shelter, I heard.
All right, I'll order pretrial release, no contact. Parties are not to reside together.
So maintain.
Um,
No
While the matter's pending, no weapons, firearms or ammunition, no contact, separate residences. You're a young man, still a lot to learn about the world. It's time to learn to navigate these relationships better. Learn the lessons now. It doesn't get easier. All right. That would conclude the matter. Next. Would you state your name, please, ma'am? What's your date of birth? We're here, ma'am, because the court has received a sworn affidavit alleging a crime of battery with domestic violence. You're presumed innocent unless proven otherwise. You have the right to remain silent today. You have the right to have an attorney represent you and aid you in this matter. I have read your financial affidavit. Do you have any dependents? Do you have any children or elderly parents that you're taking care of? All right. You do not qualify for appointed counsel, which means that after today's hearing, you're going to have to either hire an attorney, represent yourself, or I would recommend that you do seek counsel. But for today's purposes, I will ask the Office of the Public Defender to appear on your behalf, and they will do so. I have found probable cause as to the charge of battery. It's my understanding she qualifies for pretrial release.
Yes, Your Honor.
Is the state seeking anything different?
No, Your Honor, that would be acceptable. We'd ask for no contact that indicates here the victim said he would attempt to appear in court today, but apparently he hasn't.
All right. All right.
2 hours away.
All right, ma'am. I know you, I don't know. I really have no idea. You and the victim, you have a relationship. You may wish to work things out. You may not. I don't know. I am going to protect the victim, though. I'm going to order no contact while this matter is pending or unless a court issues a different order. You're not to reside together. You are not to possess any weapons or ammunition while this matter is pending. That would conclude the matter. Would you state your name, ma'am? Would you state your name? I don't know why. I don't know if it's the mic or, I know that she's speaking softly to start with, but I can't hear that at all.
With Lynn Elise.
That's better. What's your date of birth?
Oh, September 25th, 2000.
And we're here because the court has received a sworn statement that alleges a crime, that being battery with domestic violence. You have the right to remain silent today. You have the right to be represented by counsel. I do appoint counsel to represent you. I have found probable cause. I understand that she qualifies for pretrial release. Is that correct?
Yes, Your Honor.
Is the state seeking otherwise?
Your Honor, the victim is here. We'd like to hear from him.
Oh, I did, thank you. I didn't see that. Good afternoon, sir. My name is Judge McCarthy. You, as the alleged victim in this matter, have the right to address the court and let me know what you think. So would you do me a favor and raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. It's a priority of the court, especially in the early stages, right after an arrest, when we don't know a lot. I mean, we on this side of things, to make sure that victims are protected and that everyone feels safe while this case proceeds. So what I very often will order that there be no contact between a defendant and a victim, and that they don't reside together. So Is there anything about that that you would not agree with or not want?
I'm not scared with her. I just want she go home with me soon. She can with the baby.
So my understanding, I'm having a little difficulty hearing, but what I believe I heard was that you want her to return home. Is that a home that you share with each other?
Yes, and I'm not scared with her. And I don't need no state law follow.
All right, does the state wish to inquire of the witness?
No, Your Honor.
Defense?
No, Your Honor.
All right, the witness does appear to be able to defend for himself, not that that is dispositive of the question. I will order pretrial release and order no hostile contact. Ma'am, I need your attention, okay? All right? The victim in this case is telling me that he's willing for you to come home. It's only for that reason that I'm willing to consider it, but there's still going to be conditions. There should be no hostile contact. Do you understand what that means? All right. We're all human. We get our buttons pressed. Sometimes we lose our temper. But while this case is pending, and hopefully for the rest of your lives, but at least while this case is pending, you're not to raise your voice, not to bite, not to throw anything, et cetera, et cetera. You don't let yourself lose control. So I'm going to order no hostile contact. If there's any credible allegations of hostile contact, that will be a violation of a court order, which is a separate new crime. You may return to the home that you share. You're not to possess any weapons or ammunition. I'm also going to order that while you're residing in the home or in the presence of the alleged victim, that you not use alcohol or any other intoxicating substance. That would conclude the matter. Thank you, sir.
Of course.
Have a good rest of your day.
Delicious, Francois, and behavior, Your Honor.
All right, how does,
I think that to go forward, Your Honor, we did, the co-defendant, they're her sister, so.
all right, in the interest of Jesusla, Ms. Francois, I had written here that there's a companion case, I recall it. Counsel, do you waive the appearance of your client?
Yes, Your Honor.
All right, we'll find probable cause, order bond in the amount of $500. There should be no contact between the siblings, between the defendant and the victim. They're maintained separate residences. I heard previously that they do not reside together. She's to possess no firearms, other deadly weapons, or ammunition during the pendency of this case. That would conclude the matter.
Thank you, Your Honor.
When we're done, corrections, when we're done with this lady, I'm going to step back for a minute and get some water. We don't have a lot more to do, but we'll give everybody a 5-minute break when we're done with her, okay? All right, ma'am, would you state your name?
Annie Gamage,
And what's your date of birth?
November 26, 1999.
All right. Ma'am, what we're doing here today is the court's received a sworn affidavit that alleges the crime of battery. You have the right to remain silent. You will have a right to trial on that if this matter proceeds to that point. You have the right to counsel. For the purposes of today's hearing, I'm appointing the office of the public defender to represent you. I have found that there is probable cause. I see the risk assessment score and that she qualifies for pretrial release. Is that accurate?
Yes, Your Honor.
Is the state seeking anything other than pretrial release?
Your Honor, the victim is here, so we'd like to hear from her.
Oh, very good. Would we swear in the witness, please?
Raise your right hand. Do you solemnly swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth?
Yeah, I do.
State your name for the record.
My name's Tatiana Batenko.
Ms. Batanko, what is your relationship to Ms. Gamage?
My girlfriend.
Okay. And what did you come here to say to the court?
I'm not scared of her. I don't want to press charges or nothing like that. Like, she can just come home and just,
Do you live together?
yeah.
All right. Well, a couple things. One, what happens with this case, whether or not there's charges pursued, that's not up to you. It's up to the state attorney's office. And of course, there are other various things that are up to the judge as well. Was yesterday a one-time event, or do you two have an ongoing problem with physical altercations?
Yeah, it's ongoing.
You want her to come home?
I mean, she got a whole son, so I mean, yeah, I would like for her to come home.
All right. Are there any questions from the state?
No, Your Honor.
Any questions from the defense? Because of the risk assessment results, is this a first offense, State?
Your Honor, I'm seeing zeros throughout the form,
Yeah. All
and she
right.
does qualify for PTR.
Okay. All right, I have already found probable cause. I will order pretrial release. I will allow Ms. Gamage to return to her residence, which is with the victim. Here's, I'm hearing, ma'am, I need your attention, and I need you to take this seriously. I'm going to let you go home, but I'm going to order no hostile contact, all right? And quite frankly, like your posture with the court right now is already almost bordering on hostile contact. You hear me? Well, all right, no contact between the victim and the defendant. You're not to return to the residence under any circumstances except one time to retrieve belongings in the presence of law enforcement. You're not to consume alcohol or any other controlled substance. You're not to own any weapons, firearms, or ammunition. That's the order of the court.
The judge, you said no return?
No return except one time with law enforcement. That concludes the hearing. Court is in recess. Basically stretch break. I'm going to refill the water. 5 minutes or less. We're on the record, but I'm muting. Good afternoon, sir. Would you state your name, please?
Raymond Joseph.
Mr. Joseph, we're here because I've received a sworn affidavit that alleges that a crime has been committed, that being battery with domestic violence. You're presumed innocent unless proven otherwise. You have the right to remain silent today. You also have the right to have an attorney assist you. You filled out a financial affidavit. I will appoint counsel to represent you. There's an attorney standing to your left. I see that we've got some witnesses. We're going to hear from you in a moment. Is there any challenge to probable cause?
No, Your Honor.
All right. Court has reviewed the affidavit and finds probable cause. Before proceeding, I would like each of you, starting on my left, your right, with the young lady, if you'd say your name and your relationship with this gentleman, and then you in the middle, sir, and then you on the right. Go ahead.
My name is Shabril Joseph. That is my father.
All right, you, sir?
My name is Rayon Joseph. I'm the son of him.
All right, ma'am?
I'm Bibi Shanas Joseph. I'm the wife.
Okay, all right. Thank you for your patience here this afternoon. None of you are required to say anything. And I don't know that the court needs to hear from all of you, but if you want to pick a spokesperson, that would be fine. But whoever might want to address the court, and again, no one has to, please raise your right hand to be sworn in.
You solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
All right, and by the way, when I stated that we don't need to hear from each of you, that's not me saying that I don't want to. If there's something that one of you really needs to express to the court, I'll make time for it. Let me say, ma'am, when there are charges of alleging violence in a home, court takes that very seriously. If it's needed to prevent further violence or even to prevent people from being afraid of violence, I often will order there be no contact and some other provisions. So I want to hear from you and your family. What is it that you would like the court to do today?
My father, he's diabetic. He has heart problems. He has high blood pressure. He has high cholesterol. I'm not afraid of him. I want him to come home as soon as possible because he needs all of his medications. And what happened that night, he doesn't drink often. He's not an alcoholic. So he felt confused, and I understand why what happened because he didn't know what was going on. And I want him to come home immediately.
Can I ask you, ma'am, who got the police involved?
He called the police.
Your father called the police?
Yes.
Okay.
He didn't know what was going on, Your Honor.
Is that all, ma'am?
Yes, we just tried to calm him down, to put him to sleep, and he was confused.
Okay. Do either of the other two of you wish to say anything?
Raymond Joseph is my husband, and I need him to come home. We have graduation coming up, we have birthdays, and we have holidays. Please, he got confused that night because he normally don't drink so much. And he take his medication, and he didn't have dinner, so I think that make him so confused. Please, Your Honor, let him come home.
All right. I'll just note for the record that we had not sworn in the wife and mother. I think that's okay, but I will allow either of the witnesses if you have questions for them, sir.
I do. I know both of you said that he doesn't drink often. Do you want the judge to order that when he's released that he drink no alcohol or take any intoxicants while this case is pending?
Yes.
Okay.
That is fine.
And has he ever done anything like this before? Has he ever touched any of you before?
No, sir.
Okay. Ma'am?
No, sir.
Okay. All right, no further questions.
Do you have any questions for the witnesses, sir? All right. Does this qualify for pretrial release?
Yes, Your Honor.
All right.
The form says no, but she does?
Yes, he does.
Okay.
This is Raymond Joseph, right?
Yes, sir.
Correct?
Yes, sir.
Okay. Yeah, mine says yes. All right.
Mine says no.
I will, I do find there's probable cause. I will order pretrial release. Sir, you've clearly got a protective and a supportive family. I don't know you. I don't know them. We've never met. I don't know if this is a one-time thing. I don't know if if they're overplaying a little bit about how you were confused and didn't know what you're doing. And I don't want you to respond or discuss any of that. because you're presumed innocent. What I'm saying is, I don't know, but I will say this. I'm going to allow you to go home. My job is to make sure this doesn't happen again. So there's to be no hostile contact between you and any of your family members. If there's a report of pushing, shoving, yelling, hitting, that would be in violation, besides being a new crime, that would be in violation of my order as well. So no hostile contact. You're to, while it is your right as an American to own weapons, while this matter is pending, I'm going to order no firearms, other deadly weapons, or ammunition in your possession. And you're not to use alcohol or other intoxicating substances in the home, or be under the influence of anything while you're at home. Do you understand, sir? All right. So pretrial release. That's those are my conditions. That's the order of the court. He's going to come home.
Thank you, Your Honor.
Would you say your name, sir? Would you say your name?
Zachariah Keeper,
Mr. Keeper, what's your date of birth?
11/4/81.
Sir, we're here because the court has received a sworn affidavit that alleges a crime, that being battery with domestic violence. You're considered innocent until proven otherwise. You have the right to remain silent. You also have the right to have an attorney assist you today and throughout this case. I will appoint, for today's purposes, the Office of the Public Defender. There's an attorney standing to your left. I have found probable cause on this matter. I do see that this one as well scores 0 and qualifies for pretrial release. Is that accurate, ma'am?
Yes, Your Honor.
Is the state seeking otherwise?
Well, obviously, my forms are different because my forms says, once again, he doesn't qualify, so maybe.
You want to approach? Can I look?
Oh, I believe you.
Take a look. No, I want to know too. I mean, yours might be right and mine wrong.
It could also depend on when you printed your paperwork
Sure.
out.
Yeah, mine doesn't say it either. I think they're old though. They have to process.
When his fingerprints clear, yeah,
Oh,
so if
see,
you printed
I'm
it
looking
out
at that
beforehand,
sheet, and yeah.
if you look at
You're
the
absolutely correct.
timestamp.
Well, it's certainly, let me see, timestamp 4:34 a.m. versus 7:19 a.m.
So it may say his
I'm
eighth
certainly not trying to keep you off balance or at a disadvantage. All right. And that's why I inquire to verify as well.
I did note that he lives out of state.
Yes.
All right. I find probable cause. I've appointed counsel. I will order pretrial release. You and, let me see, who do you reside with, sir? Who are the members of your household?
My daughter and my mother,
And their names are?
Raya and Rosemary.
Okay, thank you. And, okay, yeah, I remember this. All right, so the potential victim is someone that is the mother of your child that you used to be in a relationship with. Is that right?
Yeah.
What part about that did I get wrong?
We just wasn't really in a relationship, but she.
Oh, okay, I got you.
Bring that out.
All right. All right. Does anyone want to inquire, based upon the court's need to clarify? All right. I found probable cause, pretrial release. So I'm going to order that while this is pending, that any collaboration or communication about time sharing with your child be done through a third party, so no direct contact with the victim while this matter is pending. And I understand that you're going to be requesting to return to your home state. I'll grant that. This matter is still going to be pending, though. You're still going to be responsible for making appearances in Florida in the appropriate court if there are indeed any other hearings in this matter. You understand that? Okay. So being out of state doesn't shield you from any of that. Any other issues from anyone?
Yeah.
All right, you're on pretrial release. That would conclude the matter.
Make sure you stay in touch, you know?
Would you state your name, please, sir?
O'Shea Russ,
What's your date of birth?
1990.
All right. We're here, Mr. Russ, because the court's received a sworn statement that alleges a crime, that being battery of domestic violence. You are presumed innocent until proven otherwise. You also have the right to remain silent. I'm appointing counsel to represent you, as it is your right. I have found probable cause in this matter. Does this gentleman also qualify for pretrial release?
Yes, Your Honor.
I don't know what your form says, Mr. Prosecutor.
Mine
but
does say yes as well.
Okay. Is the state seeking anything other than pretrial release?
Just no contact.
Do we, sir, do you have any, because I made a note about this. I couldn't really tell just from the affidavit. Do you have any other information about the wishes of the victim in this matter?
State has no additional.
Okay. All right, thanks, sir. Anything from the defense? I'm going to order a pretrial release. Do you remain in a relationship with the victim? Is that a recent development?
Trying to explain it. We live together because we have children, but we're not together. We're kind of working it out, going through a separation.
So you're sharing the home right now?
Yes, yes, sir.
All right. You think that you can coexist under the same roof without any violence repeating itself?
Yes, I do, sir.
And naturally, that's the answer I would expect, but whether it's truthful or not, but. Oh, based upon my reading of the totality of circumstances and not having additional information from the victim, I'm gonna, my order is gonna be no hostile contact. I would strongly recommend that you consider, if separation is underway, that you just make it official and maybe reside somewhere else. So here's how this works. Now, my order of no hostile contact, one, it's a court order. If you disobey court orders knowingly, that in itself is a new crime. Two, it's a condition of your release. So if there's credible evidence of heated arguments, raised hands, that would be a violation of the conditions of return, and a judge would have to revisit whether or not you get to leave here. So do you understand all that?
Sir.
All right. So it's going to be up to you to, in a mature manner, determine, can this work? Can I stay under this roof and not be at risk of ending up in jail again, or should I move out? All right, so think that through. I'll order no hostile contact, no intoxicants while in the home, including use of alcohol, no possession of weapons, ammunition, or firearms. That's the ruling of the court. Good afternoon, ma'am. Would you state your name
Charisma,
and your last name?
St. Bellis,
Okay, and can you confirm your date of birth, please?
January 31st, 2001.
All right, thank you, ma'am. The reason we're here is that the court has received a sworn affidavit that alleges the commission of a crime, that being battery with domestic violence. You are presumed innocent unless and until it's proved otherwise. You have the right to remain silent today, and you have the right to counsel which you do qualify for, I am appointing counsel to represent you. I have found probable cause. I see that this scores 0 and qualifies for pretrial release. Is the state seeking anything else?
No, Your Honor.
Is there any notion of what the victims want regarding conditions of release?
I have no idea, Your Honor.
Okay.
This was the driving incident.
Right. Right. All right, I'm going to order again, no hostile contact. So, if I had independent information, if I had any witnesses to suggest that any of the victims did not want you in the home anymore, I would grant that and order you to have no contact from what I've read. And I said a moment ago that you're presumed innocent. That is accurate. So I don't know exactly what's true. The information I do have, if parts of it are accurate, then you need to modify the dynamic in the home, and you need to modify your behavior. I'm going to order that you have, if you remain in that home, you'd have no hostile contact with anyone, which quite frankly puts you at risk. You know, if you raise your voice at somebody and somebody picks up the phone and calls the police, then now you're in violation of a court order again. So you make a decision, as I believe you're 21 years old, as to whether or not you can move out, whether you should, because I want you to take this seriously while this is pending. So you're to have no hostile contact with anyone in the household, any of the victims. You're not to possess any deadly weapons, firearms, or ammunition. While you're under the roof, while you're in the home, you're not to be under the influence of any alcohol or other intoxicants. That's the order of the court.
Okay.
Could you say your name, please, sir?
Marco Shorter.
Mr. Shorter, the reason that we're here is that I've received a sworn affidavit that alleges a crime of battery with domestic violence. You have the right to remain silent today. You have the right to an attorney. According to your financial affidavit, you do not qualify. Is that accurate? 800 weekly doesn't qualify?
No, it's 522.
Okay. Is there any child or an adult or any other family member who relies upon you to be taken care of?
My daughters are older, so I don't know what you mean, like a young child?
Yeah, I'm referring to
Not,
you.
not noticeably. My children are pretty older now.
Okay.
Yes,
All right, sir. Well, all right, so you don't qualify for appointment of an attorney at the expense of the taxpayers, but I'm going to ask the Office of the Public Defender to make an appearance for you for today's purposes. After that, I suggest that you explore hiring an attorney of your own.
Yes, sir.
All right. I do find probable cause. Does this gentleman qualify for pretrial release?
Yes.
Is the state seeking anything other than pretrial release?
Pretrial release is acceptable, Your Honor, to the state. However, they lived in separate residences. This could easily have been a burglary case. We request no contact, no return to the residence.
Anything from the defense? All right. All right. The court will order no contact with the victim. No return to the scene. If you've got any belongings there, I think you have separate residences, but to the extent, if you have any essential belongings in the victim's residence, you can return there one time in the presence of law enforcement, just for the purpose of retrieving your property. But again, no contact with the victim. You're not to possess any deadly weapons, firearms, or ammunition while this matter is pending. Do you understand, sir?
Yes, sir.
All right. That would conclude the hearing.
sir, appreciate it.
Your Honor, next on the docket was Jimmy Lorgate.
Yes, ma'am.
He refused his appearance.
I'll defer to you, counsel, how you may want to proceed.
We could reset this for tomorrow.
All right, court will reset. All right, is Mr. Louder available? Come on up, sir.
I have a probable cause challenge on this, as far as the concealed aspect of the concealed firearm charge and concealed firearm in possession of a convicted felon. I do not argue there's no probable cause for felon in possession of a firearm.
All right, we'll get to that shortly. Would you state your name, sir?
Byron Louder.
And were you born November 7th, 1989?
Yes, sir.
We're here because the court's received a sworn affidavit alleging possession of a firearm or ammunition by a convicted felon, possession of a concealed weapon or firearm by a convicted felon, open display of firearm, and under a city ordinance regarding alcoholic beverages in open containers. You're presumed innocent at this point. You have the right to remain silent today. You have the right to counsel. I'm appointing counsel to represent you. All right, let me hear your arguments regarding probable cause. And what I'm counting, possession of a firearm or ammo by a convicted felon is count 1. Possession of a concealed weapon, firearm by convicted felon is count 2. And the open display is count 3. So tell me which count you take issue with.
For the first one, the concealed firearm by a convicted felon. I mean, the fact he charges open display as well as concealed, I think speaks for itself. Nowhere in here does he say that the firearm was completely hidden. They said it was tucked into his waistband with, I believe the handle was visible. The handle of the firearm was hanging out of the belt of his pants, located the firearm in that location. Yeah, the firearm was never hidden. It was never concealed.
All right, state response if you wish.
No argument, Your Honor.
Well, I'm not stating as a matter of law that a handgun or pistol in a waistband is not concealed as a matter of law. As to the specific facts alleged, so I went through how I numbered the counts, in either you or I are off by one. I'm considering this count 2, possession of a concealed weapon or firearm by a convicted felon.
That's at 5,000, right, Judge?
Say again?
That one, that's count 2 is set at 5,000. I mean.
Right.
I have that as well. I may have misspoke earlier.
I think you said count 1 when you were arguing. Okay.
I wrote it down wrong.
Well, probable cause is a very low threshold, but my reading of this, I think the argument's persuasive. So I will not find probable cause as to count 2. Court does find probable cause as to counts 1, 3, and 4. Court's inclined to set bond as follows: as to count 1, $4,000. What was count 3, open display of firearm? I'll make that 500.
You are on count 2.
Yes, RR on count 2. Count 4, alcoholic beverage, open containers, bonded $100. Although it's almost circular at this point, given the allegations, I will order that you not possess any deadly weapons, firearms, or ammunition, sir. if you are released. Are there any other issues? That would conclude the matter. All right, thank you.
Your Honor, Ms. Robertson has a slight hearing impairment. If you can just speak a little louder, she don't need the headphone.
Okay.
Speak a little.
Okay. Man, what we're going to do is, you and I are going to make sure that we're speaking clearly into the microphone. I'm going to do my best to speak up and speak clearly. If you would do the same, I would appreciate it. If at any point you don't understand me or any of the attorneys, let me know. Would you state your name, please?
Canby Robertson.
All right. Man, we're here because the court has presented to it 2 warrants, both for failure to appear. You're entitled to the assistance of an attorney today. I'm appointing counsel to help you. Let me see. So we've got 2 warrants to deal with. I'm inclined, having reviewed them, I'm inclined to find that they're valid, that there's probable cause, and issue bond. What's that?
FTA for pretrial release on this day revoked release. So he said that no bond on this one.
Okay.
Judge Blackman.
Counsel, maybe you can help your client out with this a little bit. There was a pretrial conference as to one of these failure to appear cases that's already happened on November 1st. I don't have in front of me when the next scheduled matter in that is, but she's going to need to know so that she can show up. But I've got the warrant states revoke release. I'm going to honor that, but I'm going to reestablish a new bond. So there are 2 warrants, correct, Madam Clerk?
Just one.
Just one? Well, there are 2 counts of failure to appear. I'm going to impose I mean, quite frankly, if I knew that there was a hearing set for a day or 2, I'd just hold her over, but I don't know what's happening.
They have got a set for an arraignment for the termination of new trial date, January 10th. We don't know what's Judge Mark Blackman's pretrial date, but the JA would get it tomorrow and she would set it. And if she's in jail, we would notify the jail and they would bring her over. So I don't know if you want to give her a bond and don't show up for the JA would be in tomorrow to set for a new trial date, pretrial date.
All right, what I'm going to do today is, was she picked up today?
Yesterday?
Yesterday.
All right. Are you employed?
Yes.
Can you tell me where you work?
I work for my family's company. I'm not getting paid right now. We're behind on payments for our employees, so I've just been working for free, basically.
Okay. All right, so one of a couple things is going to happen. I'm going to allow bond on these warrants. And I'm going to read off the next known date, which is the arraignment coming up. And I'm going to order her to be present for that. If she decides or can't make bond, then she should get information within the next couple of days about being brought before the judge. Did you want to be heard, sir?
Yes, Your Honor, the state would object strenuously. These are serious felony crimes. My understanding of the administrative order is that when one circuit judge sets what the bond should be on a failure to appear, that at first appearances, that's not to be disturbed. Maybe I'm wrong about that. I did read the order recently in preparing for this weekend duty, but I think it's Judge Bleckman who should decide if there is appropriate bond. I'm looking at the KPS order and it says no bond, bond amount 0.
Zero. All right. All right, counsel. All right, I will order no bond.
I would note that Judge Bleckman is holding court tomorrow.
Okay, that's very helpful.
I am aware of that.
Although, given your argument, which I find persuasive, that it doesn't matter so much whether he's hearing on the bench tomorrow, but that is helpful. Okay, so I will order the clerk to please notify the court through JA of today's developments, and I'm going to order no bond. So the goal is not to have you languish without answers. You should be before the judge who issued this warrant within a day, possibly 2 at the most. So that's the order of the court. All right. Would you say your name, please, sir?
Ryan Thomas,
What's your date of birth, sir?
4/5 of 71.
All right. Sir, we're here because the court's received a sworn affidavit that alleges attempted burglary of a conveyance, pardon me. And what's today's case number? Is that 14852?
Yes, and we have 14853. He should have 2 cases.
Okay, thank you. All right, so there's been alleged crimes. You're assumed to be innocent until proven otherwise. You have the right to remain silent today. You have the right to counsel. I will appoint counsel to represent you for today's purposes. I do find probable cause. Court's inclined. Let me check something. Pardon me for the pause, and thank you for your patience. All right, I'm inclined to set bond as to the attempted burglary of an occupied dwelling at $1,000 and bond as to the attempted burglary of a conveyance at $1,500. As to the matters on which the gentleman has been released on his own recognizance for apparently unrelated burglary charges, I will revoke bond, or rather revoke release on own recognizance status.
You sent them all in the bond, Judge?
So there's 3 different ones, all for burglary. Do I have the authority to order no bond, prosecutor?
No, I'm not sure which case we're talking about now.
Okay, so, all right, I've set $1,000 and $1,500 on the new charges.
Yeah.
Which is under 2022-14852. I'm dealing now with I've got 3 different case numbers, all 2022. There's 12595, 12594, and 9981. First 2 are separate burglaries of a conveyance. Third is possession of cocaine and trespass.
It is my understanding, Your Honor, that if he is out on bond or on release for an offense and he commits another, then as long as the court finds probable cause for the new arrest, which you have already done in both cases, that the court does have the authority to revoke bond.
Just wanted to be clear. Does the defense wish to be heard?
Not at this time, Your Honor.
All right. I'm revoking release on own recognizance status on the case numbers that I mentioned. Are we all clear on
Yes,
everything?
yes, sir, thank you.
That would conclude the hearing.
And you said all of those at no bond, correct?
Yes. Come forward, sir. Would you state your name, please? And what's your date of birth? Sir, we're here because I have received, the court's received a sworn affidavit that alleges the crime of trespass on property after warning. You're entitled to the presumption that you are innocent until proven otherwise. You have the right to remain silent today. You have the right to counsel to aid you. And based upon your affidavit, I do appoint counsel. In your case, I do find probable cause as to the matter of trespassing. Does the state wish to be heard on what you're requesting?
Your Honor, the state has no objection to ROR, although the state would make a plea offer of adjudication based on prior record and time served. With a condition of no return.
Your Honor, Mr. Pruitt's indicated he'd like to accept the state attorney's offer.
If, okay, I'll give you a moment to go over the form. If,
Okay, this doesn't take care of that.
I haven't done anything yet about that.
You're getting adjudication. It'd be entering a no contest plea. It's called the best interest plea. Not because you assume guilt, but because you think it's in your best interest. You understand? Your Honor, we'd be addressing this as a friend of the court. So he doesn't
Yes, sir.
have the-
All right, if I had said earlier that Public Defender's office is appointed, I'll rescind that order. Thank you for, and will allow you to appear as a friend of the court. Mr. Pruitt, I'm holding up a form that's got your name at the top left and a case number. We're here in 2022 MM 8642. At the bottom right is a signature. Is that your signature?
Sir.
Did anyone promise you anything or threaten you in order to get you to sign this form? Do you believe that you understand what the form says and that your questions have been answered? Do you understand that by entering a plea, you're giving up your right to have a trial in this matter? Do you still wish to enter a plea?
Yes.
And is this, all right, I'll accept a plea of no contest. Was an admission of guilt part of the offer?
No, Your Honor, apparently from the report, he wanted to go to jail.
All right, I will accept that Mr. Pruitt has entered a plea of no contest knowingly, freely, and voluntarily and intelligently. And I apologize, I was taking notes. An adjudication, correct? All right. Court would adjudicate guilt, will sentence you to time served, which is how much time?
2 days.
Sentence you to 2 days, which is time you've already served. I'm going to order that you not return to the scene. Do you understand that? All right. That would conclude that matter. However, there's,
For costs and fines, you're going to give me a year today?
yes, I'll go over it. Thank you, ma'am. The current matter has impacted the fact that you are released on your own recognizance as to a petty theft charge. In light of the gentleman's cooperation in the interest of justice today. The court will take no action regarding that release on his own recognizance status. In addition, as to the case that we just dealt with, the trespass, I do have to order you to pay court costs. You will have a year from today's date to do it. Or within 2 months, you can report to the clerk of court and ask for a payment plan to possibly have more time. But you've got to do either one of those things. Enter a payment plan within 2 months or pay the costs in full by the end of 1 year. What are the amount of costs?
$273.
$273, sir. I do believe that that would conclude the matter.
Thank you, Your Honor.
Your Honor, next on our docket was Robert Boyd. He refused his appearance.
Thank you, ma'am.
Did we cover that at the?
Yeah, that was a move up.
Okay. Yeah, all right, that's why it's out of order. Is this Mr. Scheibel? Correct.
Okay.
Correct. And
You have to sign it.
I have to sign this?
Yes, his plea form.
I think I may have taken one yesterday that I did not.
You signed.
I did that?
I think sure you signed it.
Mr. Scheibel, will you state your name and date of birth, please?
David Shivel, 43079.
All right, how are you doing today, sir?
Better than I was 4 days ago.
All right. Well, that's the optimistic approach. I ask because we've reset this more than once this week. All right. Okay, very good. We're here, sir, because it's been alleged that you violated your probation. You have the right to remain silent today. You have the right to an attorney to assist you today. I will appoint counsel to represent you. I have read the affidavit and find probable cause. Does any party wish to be heard on any issue?
Judge, if I could have a moment to look the case up, please.
Yes, sir. It was on yesterday's docket and the one before.
Oh, no, I'm worried. I'm looking up the original VOP.
It looks to me like underlying cause is DUI, and this was a trespass that violated. That's my understanding of it.
The recommendation was for the,
Sure.
It said violation 7.
Trust.
All right.
Judge, I don't know why the county court judge posted or ordered no bond for these violations, but even in your discretion.
I'm very glad to hear that you're feeling better. So you just got out of the hospital and back to this facility today?
Yeah, I fell down or something inside the bathroom of a gas station. I think I had a seizure, black flu.
Okay.
Pulled out and they thought I was sleeping in there or something.
Right.
For trespass. And then I went to to the hospital. For 4 days.
Okay. You have a court hearing in 3 days with Judge Gibson. Her order was that you be held until that time. That's what I'm going to do. Keep in touch with your attorney. If you're not heard before the court on December 29th, I think you would have a right to revisit this issue. But I'm going to honor the no bond request at this time. You should be seen in 3 days. Take care, sir. All right. Yep. Go ahead, Mr. Is it Hulse? Okay. I did see that there were mental health issues. I will defer to defense. You want to roll this or?
If we could, Your Honor.
Okay. All right. I'll note that at least this weekend, it's not been reset prior to today. So. And Teodros Cabete? Counsel, how do you want to proceed?
If we can reset him too. I only say that with the county ordinances because the potential for him to resolve.
Is there any other business before this court?
None from the defense.
No, sir.
All right. Thank you all for your work today on what otherwise was a court holiday. To all the parties involved, all the staff. Thank you. Court is adjourned. All right, we're here in the matter of Premraj Karan. If I'm mispronouncing any part of that, it is not intentional. Would you state your name, please, and your date of birth?
Raj Karan, date of birth is 10/27/78.
All right. We've got two matters. Gentleman's out on bond in 22 CF 12623. And, sir, there are new charges that in the form of aggravated assault with a deadly weapon with domestic violence. I have looked over the paperwork and I have found probable cause. Does the state wish to be heard on any issue?
Yes, Your Honor. If the court has jurisdiction, we would ask that you revoke the bond on the possession of MDMA ecstasy charge.
All right, sir. Defense, do you wish to be heard on any issue?
Just that my client's risk assessment is 0, and as far as the out on bond case, the state has not decided to pick up charges at this point in time, so I think it would be premature to revoke that bond on a case they haven't even made a filing decision on.
All right. All right, if I've read the level of the offense accurately, the court has decided to set bond at $5,000 on the new charge. On the 2022 CF 12623, I will revoke bond but reset a new bond in the amount of $1,000, which was what the original was. All right. Yes, ma'am. All right. Any other issues?
Any condition, Judge? Any no contact?
If and when you bond out, sir, there's to be no contact with the alleged victim, who I believe you share a home with. So that's not her fault. That's me saying it. No contact, no return to the scene. So you're going to have to find a new residence when you bond out.
And then with a one-time return, Your Honor.
Yes. Thank you, Madam Clerk. That would conclude the matter.
To get your items, you ought to call the sheriff's office first, not 911.
Would you state your name, please, sir?
Martinez Carlos,
All right. And what is your date of birth?
03/22/95.
All right. Are you doing all right today, sir?
I barely can't even speak
Why is that?
because they had me in a cell with no water, no food, nothing for like a whole day.
All right, sir. Well, we're here because the court has an affidavit that alleges a crime, in this case, trespass on property after warning. I do find that there is probable cause. You're also currently out on bond on another matter, sir?
Yes, sir. I actually went.
All right, that's okay. Are you employed, sir? Are you employed?
Right now,
Yes.
I do side work here and there at a temp agency.
Okay. All right, one moment, please. All right. I found probable cause. Mr. Martinez, you're considered innocent until guilt until and unless guilt is otherwise proven. You have the right to remain silent, which your counsel has already advised you of in some form.
This is trap.
And as I said, I'll appoint counsel. I'm going to issue bond in the amount of $500. The court's taking into account for some reason, I've got the advice to defendant for first appearance. I've got denoted as unable to sign. I've got an inmate appearing before this court today saying that he's not be given access to water. I'm not suggesting that I find that credible. I don't know one way or the other. I'll just note it's on the record. This is public. The judge has heard that he's not being given access to water. This facility is to make sure that he has access to food and water. Bond as to $500. This is sir, you can't, I don't know what's true or not, and don't respond to this, but from what I read, you had ample opportunity. You knew you were trespassing. You knew that you were ordered not to be there. The fact that you were arrested, I think, is a choice that you made. Again, I'm not assuming this is true because you haven't been to trial yet, but to the extent that any of it is true, let that be advice to you. Don't be trespassing there at that location anymore. I will order no return to the hospital where the trespass location was. Bond is in the amount of $500. I'm taking no action on the fact I'm not revoking bond on the earlier matter. That would conclude the matter. Next case, please. Would you state your name, please, sir?
Gene Wong Park,
And what's your date of birth?
July 9th, 1982.
Sir, you're here because the court has received an affidavit that alleges 2 counts, alleges that a crime may have occurred, 2 counts of battery. I have read the paperwork. I will find that there is probable cause. Before I proceed, I do wish to inform you that you have the right to remain silent. If this matter goes forward, you will have a right to trial. You have a right today and at every hearing before the court to have an attorney present. For today's purposes, I'm appointing the public defender. There is an attorney standing to your left. I found probable cause. The court is inclined to order bond for $500 as to count 1 and $100 as to count 2. 1 second, please.
Your Honor, my client indicated he's homeless. He doesn't have any financial. The court would take that into consideration for any bond amount or term of release. You can have him checking in with the public defender's office bi-weekly, weekly.
Are you transient, sir? Do you have a home?
No, I'm homeless.
So where do you, if you weren't here, where would you be laying your head tonight?
I'd be at the Mercy Drive Aspire Health Partners.
Does the state wish to be heard?
So, Your Honor.
Please have mercy on me, sir.
Well, first of all, whatever I decide about your release,
Yes, sir.
you'd have no contact with Mr. Ostendorf or Mr. Boyer.
Yes, sir, no problem.
I don't want you to return to,
Oh, no.
I'm trying to look. I don't know if it's just an intersection, North Orange Avenue and East Central Boulevard. Is that a park or what
No,
location?
It's a downtown area where the nightclubs are at and the bars. I will not return.
Battery's battery. It's a crime.
Yes,
It's something that people are punished for a good reason. You need to take this very seriously. I'm going to release you with the following conditions. You're to check in with the public defender. This is subject to verification by the state if they do make official professional inquiry to the public defender's office, at least twice per week. On Tuesday and Friday of each week, you are to make contact with the public defender assigned to your case so that we know that you're available, that you're following the rules and not getting in any other trouble.
Thank you, Your Honor.
And I'll order no contact with those gentlemen.
Yes, sir.
That would conclude the matter.
So, Your Honor, your ROR, it's going to be an ROR?
ROR with conditions. Yes.
But it's very important. Have a good day, sir.
Is this Mr. Pagan?
Mr. Battle, sir.
Okay, because I know what I had next up was Pagan, which if I remember correctly, I think he refused. I forget if it was medical or if he refused yesterday.
The hospital?
Am I out of order on these?
No, need an expert mover person.
Okay. Do we have Luis Pagan, AKA Luis Antonio Ortiz? You didn't come?
My notes say yesterday from yesterday, he was in the hospital.
I'm having a hard time hearing you, I'm sorry. Mental health today? All right. Defense counsel, how do you wish to proceed? You want to waive his appearance, or I'm willing to roll this again. I'll be here tomorrow.
Okay, Your Honor, I'll be back tomorrow, so.
All right.
Thank you, Judge.
Give it one more day. Is it that much? Okay. Well, then remind me tomorrow. All right, if this gentleman would come forward to the podium, state your name and date of birth, please. I'm sorry? Well, I was about to find out. That's why I asked them to say their names. All right. That's who I've got next. All right. We don't mean any confusion, sir. Thank you for your cooperation.
So does that mean it's a reset for tomorrow?
Pagan, yes.
Okay.
That got, I remember that this came up yesterday as well, so I'm willing to do it one more time, but the court's gonna have to take some action tomorrow. All right, thank you. All right, now, sir, would you state your name and your date of birth, please?
Yes, sir. My name is Greatest Sean Battle, Your Honor, sir.
And your birthday?
My birthday is September the 12th, 1965.
Okay, thank you. Sir, we're here because the court's received an affidavit that alleges certain crimes, battery with domestic violence, eluding police, resisting an officer without violence, trafficking in cocaine in excess of 28 grams, and possession of cannabis less than 20 grams. You are presumed to be innocent, and you have a right to be considered innocent until or unless guilt is proven beyond a reasonable doubt. You have the right to remain silent today and at every proceeding. You have the right to counsel. If you cannot afford counsel, one will be appointed for you. I do have a financial affidavit. I've been informed that you do not qualify for appointment of counsel. I know that these forms are filled out very quickly here at the courthouse, but I'm going to rely on that for now. What that means is I'm going to appoint the Office of the Public Defender for today's purposes to appear for you today. After that, you either need to, if there's any inaccuracies on your financial affidavit, you either need to correct those or hire your own counsel. You understand?
Yes,
Right.
I understand, Your Honor.
But for today's purposes, you've got an experienced, competent attorney standing to your left. I have reviewed the affidavit on the various charges. You find that there is probable cause. Court is inclined to set bond as follows. There are 5 counts, as I understand it. First, as to the battery, domestic violence, I will issue a bond in the amount of, one moment, please.
Your Honor, I actually have a PC challenge on that. The only evidence.
All right, let's hear that before I proceed.
Just, all it says is that they responded to a domestic violence call and says broke jaw. The alleged victim believed there was a broke jaw and that somehow Mr. Battle was the suspect.
Your Honor, on
Yes, sir.
page 3 at the very top, while I was interviewing Gredis, Officer W. Jackson interviewed Karen, who stated to him the following in a verbal statement. Karen and Gertis were in an argument over Gertis cheating on her. During the argument, Gertis threw her to the ground and hit her in the face, cutting it.
I must have missed that, Judge. I'll
Karen, okay, and then they were legally married. That's at the top
Okay,
page.
all right, that's fine. That's fine. The court does find probable cause as to all 5 counts. As to count 1, a bond is set in the amount of $1,000, although the court will admit if there were more evidence corroborating that there was a badly damaged jaw, the court may have adjusted that, but I will order no contact with the victim, no return to the scene of that incident. As to count 2, fleeing and eluding a police officer, the bond amount is $1,000. As to count 3, resisting officer without violence, the bond amount is $500. As to count 4, trafficking in cocaine in excess of 28 grams, bond is in the amount of $50,000. As to count 5, possession of cannabis under 20 grams, bond is in the amount of $250. I've already stated the victim in the charge of battery. There's to be no contact, no return to the scene. I'll order Mr. Battle not to possess any firearms, other weapons, or ammunition while this matter is pending.
Mr. Battle indicated he won't be able to afford the $50,000 bond, would the court consider lowering that to amount that would be feasible?
I don't know Mr. Battle. We've never spoken. We've never met before.
25,000 would work for him?
I will, he certainly, as to finish my thought, not saying he doesn't deserve to be fully heard on that matter. He does. I think my order is in line with the law, and it is the determination of the court. He is welcome to seek relief in a bail modification before the division judge. That would conclude the matter.
You gotta hire a private attorney first.
Sir. They got,
You can't have contact with your
they got my glasses.
We could go forward with his, Your Honor.
All right, thank you. We are on the record in the matter of Mr. Robert Boyd. He's got, well, we're here, I believe, on 2 counts only, aggravated stalking and contempt of court. What was the reason he refused? Is that right? I have some questions about this. We'll recall it tomorrow. All right, sir. Would you state your name, please?
Kendall Hamlet Mills.
And what's your date of birth?
03/31/1973.
All right, sir. We're here because the court has been provided sworn information that suggests that a crime may have been committed in this case. There are 5 counts: escape or attempted escape, battery on an officer, firefighter or EMT, resisting an officer without violence, and 2 counts of battery.
Your Honor, we have a probable cause challenge on the escape charge.
Please proceed.
It's alleged that, I'm not sure where the escape comes into play because he never leaves the car. I know he did damage to the police vehicle. That's a criminal mischief, not an escape. I would actually argue, based on the affidavit, that my client was compliant with the officer, that she had to put him back into handcuffs. She pulled over on the side of the road, had to put him back into handcuffs, and eventually he turned about his background and allowed her to place him back into handcuffs. I don't dispute the fact there was damage done to the vehicle. It's just this wasn't an escape. There's nothing to indicate he was trying to escape, only that he was trying to cause damage.
State?
Your Honor, it isn't a question whether he escaped. It's clear he did not, but he attempted to escape, and that's based on the fact that he slipped the handcuffs off of one of his own hands. That, I believe, is the basis for attempted escape. And that's found at the end of page 2, very top of page 3.
Right, and I'm not disputing that he took the handcuffs off, but that is not an escape because he's still locked into the back of a police car. There needs to be an overt act in order for there to be an escape. The overt act, in the state's opinion at this point in time, is that he slipped out of the handcuffs. That's fine. Where's the overt act as far as the escaping out of the police vehicle?
One moment, please. Court's reading of 944.40. There are three terms of art that are important. The first is the word prisoner. Second is the word transported. Third is the word confinement. Fourth is the word escape. I think it may be too fine a legal point to discuss whether someone detained, not yet charged, is a prisoner. So I'm not going to engage in that legal calculus at this point. I don't believe there's any difficulty with the court, being that he was being transported to a place of confinement. Comes down to the definition of the word escape. For today's purposes, for first appearance, of course, this court does not control what charges the executive branch may choose to file later or pursue later. I agree with the argument that there is no probable cause as to count one, prisoner escape or attempt to escape. Now, it's certainly resisting an officer, certainly resisting arrest without a doubt. But there's not enough, I agree with the argument. I do not find probable cause as to count one. As to counts, the remaining counts, the court does find probable cause. Your question, Madam Clerk?
You could release them on that count, on count one.
On count one. In the course of doing this, I think I lost my note. Here we go. All right. I do find probable cause as counts 2 and 2, 3, 4, and 5. As to count 2, amount of bond for battery on an officer, firefighter, EMT is $10,000.
Your Honor, it's alleged he grabbed their belt, the officer's belt. Like, there's no real harm or violence done in it. It's touching for the most part. I was actually worried about the second battery on the third-party witness, kind of conclusory terms. But I'm not saying there's not PC here, but these aren't severe crimes of violence, especially against a law enforcement officer.
Well, it's rated in the bond schedule the way it is because of the importance our society and our community places on the ability of certain public servants to go about their business without being in fear. It's not an unreasonable amount of bond. Yes, sir. He does qualify for PTR. This is a lot of things going on for someone who qualifies for pretrial release. I know. Thank you.
Mr. Hamlet Mills is a resident of Orange County, or Ocoee, rather, for the last 14 years.
I can order both pretrial release and bond. Here's what I'm willing to do. I'll order pretrial release. I've already found no probable causes to count 1. I'll reduce my order of a $10,000 bond to $3,500. Count 3, 150. Count 4, 150. Count 5, 150. And order to comply with the conditions of pretrial release. No contact with any of the victims in any of the counts. No return to the scene.
So the bond plus pretrial release.
Yes. That would conclude the matter.
Thank you, Your Honor.
Okay. Sir, would you state your name, please?
Michael Larry Jackson, Jr.
Good afternoon, sir. Would you tell me your date of birth?
January 12th, 1983. Sir,
We're here because The court has gotten a sworn affidavit that alleges a crime, specifically battery by strangulation. That is also domestic violence. You're presumed to be innocent until and unless it is proven otherwise. You have the right to remain silent. You have the right to an attorney. I'm appointing public defender to appear on your behalf today. However, I'm informed that based upon your signed financial affidavit, you do not qualify for ongoing appearance on your behalf by the public defender. So you're going to have to make other arrangements and find legal counsel. But as I said, I'm going to ask public defender to stand in for today's purposes. You have an attorney standing to your left. I have reviewed this matter. I do find probable cause. State, this is a serious allegation. I have looked at the range of amounts that I can set for bond, but I also note that he qualifies for pretrial release and scores 0 on risk assessment. What is the request of the state today?
Well, Your Honor, there are two concerns from the state. The first is that, well, the victim in this case is also arrested and will be coming up later today. So they've both been arrested. And I'm not sure if the court caught that. And then, that's Rashonda. So she'll be coming up later. The other thing that's of concern is that apparently back in May of this year, the defendant was arrested for domestic violence, battery, touching, or striking the same victim, according to the information from the BRC.
Okay. Defense, you wish to be heard?
Just briefly, Your Honor, just that as PTR pointed out, he does qualify. As far as any, I mean, we could bring her up. I don't know how the court wants to parse that out, but I don't believe that he presents a risk of threat to harm. If you actually read the police affidavit, in this case, he was not the aggressor. I'm not saying that he's not at fault for anything here. I do agree with the court there's probable cause. I would just highlight the fact he was not the aggressor in this situation. He was struck first.
Your Honor, regardless of the who struck first situation, she says that she was choked and that she was, that she felt she was going to pass out because of how hard she was being choked.
I will also say, Your Honor, my client does have injuries to his face as well as scratches. When she comes up here, you'll see the size difference. It's negligible. If anything, he's smaller than her. I think that's a very important fact moving forward in this case. Additionally, Your Honor, he indicated he does have a separate residence. We can do the no contact. We can put them in different places. I think that would be more than sufficient to quell any concerns about harm to the community or flight.
Client on bond or probation for anything else? I mean, I heard about a prior domestic violence.
I don't see anything, Your Honor.
Okay, just a minute, please. Well, the important thing at this point is to stop the domestic violence. Set bond in the amount of $2,500. You're to have no contact. Do you have kids together?
No, sir. We raised, I'm so sorry. For the past 11 years, we raised children together, but we don't biologically have kids together.
All right. You have no contact with the victim. You're to maintain separate residences. You're not to, even though weapons weren't mentioned. I don't believe in this. You're not to, while this matter is pending, you're not to possess any deadly weapons, firearms, or ammunition. You understand, sir?
Yes, Your Honor.
All right.
Thank you, Your Honor.
That would conclude the matter. Sir, would you state your name, please? Oh, sorry, ma'am. Would you say your name, please?
Amari King,
What's your date of birth?
August 25th, 1999.
Ma'am, you are here because there's been an affidavit filed that alleges certain crimes. One is aggravated battery with a weapon. The other is battery domestic violence. The court has reviewed the paperwork that's been filed and the sworn statements and the arrest affidavit. I do find that there is probable cause. I hear arguments, start from the state. Do you have a recommendation regarding conditions of return, of release?
Judge, obviously, there needs to be no contact, no return, separate residences.
Does she wish to be heard, sir? And I'll give you
It
a
does
moment.
not qualify for PTR, according to this.
Your Honor, just that my client doesn't have any financial savings, or any financial means, rather, to post any monetary bond in this case.
You know, I looked at this quite closely earlier. And I'm just double checking my notes on this. This is a second-degree felony as charged, correct?
I'm sorry, Your Honor, I missed that.
Well, that was really, it's not your job to, that was really pointed toward the state.
Ag battery is a F2, yes.
I think we're all fortunate that if what is alleged is true in any way, we're fortunate that consequences were not significantly more serious. I will set bond in the amount of $10,000, order no contact with the victim, no return to the residence. Defendants to possess no firearms, other deadly weapons, or ammunition while this matter is pending.
Count two.
Oh, battery domestic violence? Let's make that 500. Correct, ma'am? No contact, no return, no weapons. That would conclude the hearing. All right, the court is jealously defends the due process rights of everybody before the court, but the time to confer with counsel is before, not after. We need to keep things moving. Sir, would you state your name, please?
It's Nyan Pointine.
What is your date of birth?
October 31st, 1990.
All right, sir. We're here because the court's been presented with an affidavit that alleges a crime. In this case, is violation of probation. Correct, State? One count VOP?
Yes, and there's another case too.
Well, let's make sure that I've got that straight.
There's a battery DV.
Is that a new law or what he was on probation for?
I believe it was a new. Believe.
UV's new. Okay. All right.
I believe it's a new law.
All right. All right, thank you. Sir, you have the right to remain silent. You have the right to have a trial in this matter. If this proceeds, you have the right to counsel. I will appoint the Office of the Public Defender. There is an attorney standing to your left with whom you've already been conferring. I've reviewed the matter, and I do find probable cause both as to the violation of probation and as to the battery domestic violence. The court is inclined, as to the violation of probation, to order a bond of $500. As to the battery domestic violence, order a bond of $3,500.
Your Honor, may the state be heard?
Sure. I would also be ordering no contact with the victim, no return. Yes, sir.
The violation of probation, according to the records, he qualifies as a felony offender of special concern under the Anti-Murder Act, and I believe he's not entitled to any bond. That would be VOP only, not on the new charge.
Sorry to put you on the spot. Can you point me to the statute number?
Oh, yes, Judge.
Well, let's, no, it was for $3,500. Yes, ma'am. I'm going to revisit the violation of probation.
I believe it's statute 903.0351.
Thank you so much.
State, if you could just make sure that's right.
Sorry. You said 903?
Yeah, I'm like 99%. 903.0351. Yeah, that's it.
All right, is there, does the court need to adjudicate whether or not, or is there any issue as to whether or not this gentleman is a violent felony offender of special concern? All right. All right, it's a shall, or rather a shall not. Bail or any other form of pretrial release shall not be granted prior to the resolution of the probation violation hearing or the community control violation. Statute says what it says, so no bond as to violation of probation. All right. That we conclude the matter.
Judge, you said bondo on the other charge,
I
correct?
did.
And that was how much, sir?
$3,500, and then I had conditions regarding no contact, et cetera. Ma'am, would you state your name, please? Just one sec. So that's who we just did, right? Yes. Okay, thanks so much. What's your date of birth, ma'am?
229.
Ma'am, we're here because the court's been presented with a sworn affidavit that alleges that there's been a crime, in this case, it's battery with domestic violence. You're presumed to be innocent unless and until that is proven. You have the right to remain silent today and throughout these proceedings, other proceedings in this case. You have the right to an attorney. If you cannot afford to hire one, one will be appointed for you. The court has received and reviewed your affidavit, so I will appoint the Office of the Public Defender. There's an attorney standing to your left. I've reviewed the affidavits. I do find probable cause.
Judge, this is the co-defendant, the one we already handled, Michael Jackson.
Right. And that's why I paused. You see Jackson is from about 5 back. Yes, ma'am. Okay. All right, I do find probable cause. The other one arrested in this incident was before the court just a little bit ago. I understand that these things are complicated. I don't pretend to know the truth of everything. I have to go on what is sworn before me today. I will state that if there's any truth to the affidavits, that both yourself and Mr. Michael contributed to this situation. Hopefully that will stop. I'm going to order that you have no contact with the victim. You're to maintain separate residences. It's not forever. I'm not trying to change the course of your life. But while this case is pending, that's the order of the court. I'll set bond in the amount of $2,500.
Your Honor, are you going to set the same conditions as the other individual or no? You would no contact, maintain separate residences,
I
possess
thought
no.
I had just said that.
Did you?
I thought I did.
I apologize. I'm
That's all right.
doing so many different things here. I missed it.
No, it's all right.
I'm very sorry.
The answer to your question is yes.
I apologize.
All right. Would you state your name, please, sir?
Harold Ferdinand.
All right, sir, you have the right to remain silent. You have the right to have counsel represent you. I'm appointing counsel. I have been presented with an affidavit. The crime alleged is battery. I do find probable cause. The court sets bond at $1,500. I'm inclined to order no contact with the victim. If any party wants to be heard on that, I will consider it. Otherwise, that would conclude the matter. All right. Is this Mr. French? Would you state your full name, please?
Elijah French.
Sir, the court has received a sworn affidavit that alleges the crime of battery. You have the right to be considered innocent until proven otherwise. You have the right to remain silent. You have the right to an attorney. I am appointing counsel to represent you. I have reviewed the affidavit. I do find that there's probable cause. I will note that the gentleman qualifies for pretrial release and scores 0, so I will hear from the state and defense as to what you're asking the court regarding release.
Judge, state would have no objection to the PTR. We would strongly recommend no contact. There was statements that he was shouting he would kill her. So we would ask for no contact, no return to the residence.
Defense?
Nothing from the defense, Your Honor. We'd be interested in PTR.
All right. I will order pretrial release. I'm not setting a separate bond amount. I don't know the truth of everything that goes on within your household, sir, and I do hope that you parties can work on your relationships. However, for now, while this is pending, I'm going to order no contact with the victim. You're to maintain separate residences. That would conclude the matter. No, I just said separate residences.
One-time return. PTR will walk you through it. They'll help you. Have a good day.
Come on up, sir. Go out to the podium. Could you state your name, please?
Your Honor, my name is Kiahi Dean Mikiela Holder.
All right, sir, the court has received a sworn affidavit, which I have reviewed, that alleges a crime. The allegations are battery, domestic violence. You are presumed innocent at this point. However, the court needs to deal with the allegations. You have the right to remain silent. You have the right to an attorney. The affidavit that you filled out tells me that you do not qualify for the appointment of counsel permanently. However, for today's purposes, I will ask the Office of the Public Defender to appear on your behalf. After today, you're going to have to make some sort of arrangements. I do recommend that you hire counsel to represent you. You can also ask someone to go over your financial affidavit again and see if you made any errors. Now, I do find there's probable cause. This is another one state where I see qualifies for pretrial release with a risk assessment of 0. What are you asking of the court?
Your Honor, the concerns of the state, well, first off, we would note that according to this report, the victim was herself under the influence of alcohol, not to minimize the crime, but it may affect somewhat what she indicated. But there was a discussion with the child, 8 years old, diagnosed with autism, and he apparently saw the choking of his quote-unquote mommy. I'm not sure how to solve that. This case says DCF was not notified. It would seem to me that this is a case where DCF should be notified and that there should be conditions to comply with any requirements of DCF. I'm not sure PTR can properly supervise under these circumstances.
All right. I will order a pretrial release. I won't set a separate bond amount. You'd have no contact with the victim, sir. No return to the scene other than one time to retrieve belongings if there are belongings there. This is not forever necessarily. I don't know what will become of your relationships in the future, but while this is pending, that's the order of the court. I will order that the state refer this to its sister agency, the Department of Children and Families, and apprise them of this. I'm not going to prophylactically order blanket cooperation with the Department of Children and Families for various reasons, but I do want this referred to DCF so that they can investigate. No contact with the victim, no return to the scene, except for one time for belongings. You're not to possess firearms or other deadly weapons or ammunition, sir. That would conclude the matter. Yes, ma'am. State?
No objection as long as he maintains contact with PTR.
Permission granted. We're a big country, I know that, and sometimes you can get lost for, a day or a week or so, but we're one United States. So if you go to another state and violate the terms of this Florida court's orders, you will end up back here, and you will be facing that. So I will allow you to return to your residence in another state. but you have to be responsive to what's going on in this case, or there will be big trouble. All right? Yeah? Yeah. All right, that would conclude the matter. Is there, counsel, I perceived a little confusion. Usually, you know, people understand, even if they disagree with the court, they understand what I'm getting at. Do you think your client understands what's required? All right, very good. That would conclude the matter. Ma'am, would you please state your name?
Me, Rebecca Johnson.
All right. Ma'am, you're gonna hear a lot of things come at you pretty quickly here. If you have any questions, that's okay, but please just listen as carefully as you can.
Yes, sir.
What did she say?
She said yes, sir, Your Honor.
Okay, very good. Are you not feeling well right now?
I'm okay.
Okay. We're here because I've received an affidavit that is sworn. It alleges that a crime has occurred, that being battery, domestic violence. You have the right to remain silent. You have the right to an attorney. Counsel is appointed to represent you. Court has found probable cause regarding the allegation. I do see that there is a witness here who wishes perhaps to address the court. Can I ask you to identify yourself?
I'm Brian Evans. Sir, I don't want to.
Hold on a second. We're going to swear. You don't have to say anything to the court, but if you want to, we're going to swear you in first, okay?
Okay.
Raise your right hand.
It's been a big mistake.
Raise your right hand.
Huh?
The other right hand. Do you solemnly swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Sir, I'm not in danger from this old lady. It's been a big mistake. I was mad. I kind of deserve it. I did some things, and I make a lot of mistakes in my life. And this one, another big mistake that I did. I caused this. You feel me? I came to later life, played around, did something I shouldn't did, was disrespectful. You feel me? Of course, I think I deserve to get sprayed with mace, be honest with you. But I did, and I'm ashamed of it. You feel me? This has been a big mistake. This lady never been in trouble. She come to this country, bust her ass, work hard, and take care of her grandparents and stuff like that. What I did was very wrong. I'll pay all the penalties for it. Yeah, I was kind of mad at first until I realized I am a grown man and I'm not in danger from this damn lady. It's a crime down. I feel embarrassed coming up here. And I stayed up all night, couldn't sleep because I know I was mad and I might be a little dangerous for her. And she might be a little scared of something like my lifestyle, you feel me? And I got to understand that of me being selfish. I was very selfish. You didn't understand I really hurted her bad. She did nothing but help me. God on the truth.
All right. Thank you, sir. You are Brian Evans, is that correct?
Yes, sir.
Okay.
I'm not going to press charges or nothing like that. I was kind of mad at first because the people, the crowd of people that come, it's Christmas Eve. Like, Lord have mercy. I'm going to pay for this. Karma will come back on me for this.
Well, I do need to give these other attorneys the opportunity to ask you questions if they wish to. State anything?
No questions.
Man, look at the age of this woman, man. Look at me. I'm the one, the dangerous one. Come on, dude. Y'all get real with yourself.
All right. I can assure you that the court is real.
Yeah. Please give me mercy. I made a mistake. I should have just been a man and just didn't bother with people and handle some stuff on my own, started using people. You feel me?
Okay.
I made a big mistake in my life. I made a couple of mistakes in my life from a long criminal history that I wish I could take back too. You feel me?
Yes, sir. All right. We're going to proceed. It should go without saying that the suggestion that someone deserves. Hold on, sir. It's the court's turn. It is. I don't mean any disrespect, sir, but I have to maintain order. Whether or not the victim, quote, deserved it is immaterial. I found probable cause that a crime has been committed. However, this particular defendant qualifies for a pretrial release. Is that correct? Correct. Score is 0. Is there a recommendation of the state?
PTR, I can't see any need for any other conditions, given the statements of the victim.
The state is being very generous with you today. You don't mace people. If you're not defending yourself, that's what it is. It's a weapon, and it's a defensive weapon. It's not a disciplinary tool. It's not an attention-getting device. It is a weapon. I will release her to pretrial release. There's to be no hostile contact between the parties, between the defendant and the victim.
No, sir.
The defendant, that's fine. I don't have time for it, though. Everything that I'm saying will be explained to you. It will, okay? No hostile contact, no possession of any firearm, other weapon, or ammunition. For today's purposes, the court will be explicit that any chemical weapons, to include mace or pepper spray, are contemplated as weapons within the meaning of today's order. That's the order of the court.
Sir, I had a question.
Sir, she's about to leave, and I can't discuss the case without her present. There's no disrespect meant. Please contact either the state attorney or public defender's office if you have further questions.
She'll be processed out in the next couple hours.
Would you state your name, please?
Jessica Kendrick,
What's your date of birth?
11/18/27.
And we're here because there's been an affidavit filed that alleges a crime. In this case, it's battery with domestic violence. You have the right to remain silent. You have the right to counsel. I'm appointing counsel to represent you in the form of the public defender's office. There is an attorney standing to your left. I have reviewed the affidavit in this matter. I do find that there is probable cause. There's also another matter. I believe she is on bond for another matter. I will take that up separately. Court's inclined to impose a bond of $500 in order no contact with the victim. Oh, I did not, with apologies, I didn't see that there was a victim here. And you have been waiting quite a while, ma'am.
Yes,
Would you state your name, please?
Ava Kendrick.
I'm going to have you raise your right hand, and so we can swear you in.
Okay.
You solemnly swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, you don't have to say anything, but you spent all this time being here. Is there anything you want to tell the court?
My daughter, I didn't want to press charges. There was someone else there that did. There was another witness there that talked to the police, and the police decided to file charges. My daughter didn't hurt me. She had an anxiety attack. She does have issues with drugs, and I'm worried about her. I want her to get help. I don't think that she can get the kind of help she needs in prison, in jail.
Do you and your daughter reside together?
No, we don't.
Does anyone want to, is that all? Is there anything else you wanted to say?
Well, she doesn't have a place to stay. She's just stays from this person to that person to this person.
All right. Does anyone, does the state wish to ask any questions?
No questions.
Defense?
Ma'am, would you be willing to allow your daughter to stay at your house?
Yes, I would be okay.
Okay. And you previously, as reflected in the arrest affidavit, told law enforcement that she didn't hit you, but there was a grabbing instead?
Yeah, it was.
Okay, but
she
no
had an
punching,
anxiety.
right?
Right, no punching.
Despite what law enforcement said in the report?
She didn't punch me, no.
Understood. All right, thank you, ma'am. Nothing further, Your Honor.
So by that line of questioning, are you challenging whether this incident happened at all?
The ICPC here, Your Honor, that's even with the grabbing under Florida statute.
All right.
I would just.
So here's what I'll do. There is in addition a bond currently for trespass and conveyance. I will take no action on that. In this matter, I'll find probable cause and order a bond in the amount of $500.
How much, I'm sorry?
500. You were to have no hostile contact with, that's your mother, right?
Yes.
You'll have no hostile contact with your mother. You're not to possess,
So I can't.
you're not to possess any firearms, weapons, or ammunition while this case is pending. In addition, if you reside with the victim, I'm ordering you to abstain from alcohol or other mind-altering substances. That's the order of the court.
Your Honor, would the court consider a no contact also with the boyfriend, Robert Newdigate? As you probably recall, they were involved in criminal activity together.
Granted, no contact with, say the name one more time.
Robert, last name is Neuddigate.
That's granted. All right, that would conclude the matter. Sir, would you state your name, please?
Manuel Christopher Lampkins.
Hello, Mr. Lampkin.
How you doing, sir?
I'm doing well, thank you for asking. We're here because the court's received an affidavit that alleges crime of battery with domestic violence. Court does note in reviewing this that there are children present. You have the right to remain silent. If this, you have the right to a trial. You also have a right to counsel. I'm appointing an attorney for you. I do find probable cause. The court would set bond in the amount of $2,000. I'm inclined to order no contact while this is pending. That no contact is with the victim, not with the children, so you're going to have to find a way to figure out how to spend time with the kids without having to involve the victim. And do you live together, sir?
No, sir.
Huh?
No, sir.
Okay. All right, no return to the scene then. All right, that's the order of the court. Sir, would you state your name, please?
Ross Allen Mills.
Sir, we're here because the court has received a sworn statement that a crime is alleged to have been committed, that crime being battery, domestic violence. You have the right to remain silent. You have the right to have counsel present. I'm appointing counsel to represent you. I do find that there is probable cause for the battery. So the alleged victim is this gentleman's twin, is that correct?
Yes, Your Honor.
Do you all reside together? All right, any recommendation from the state?
Your Honor, he does not qualify for PTR. no objection to him being able to leave the state to go back home as long as he returns when needed for court. No contact with his brother at this stage till we know what they would like to do.
Has your office heard from victims at all?
Oh, I doubt it, sir. Obviously, this happened yesterday. Nobody's there.
Anything from the defense?
We would just ask for $1,000 bond based off the facts of the case. It's alleged they were playing Risk, and the argument got heated. My client didn't get physical, or it's alleged, until after the alleged victim started cursing at my client's wife. I believe there was a throwing of a piece of the board game too, but just based on these facts, Your Honor, we'd be asking for $1,000 bond.
I found probable cause. I'll grant the request to set bond at $1,000. A couple of things, sir. Don't respond to this, because as I stated earlier, you're presumed innocent, and you do have the right to remain silent. I don't want to downplay this. It's battery. It's a crime in this state. You have to deal with it. The fact that it's your brother, you've obviously been very close for a very long time, doesn't change that. He has the right to be protected from violence just like you and I and everyone else does. So I'm going to order the $1,000 bond. I'm going to order no hostile contact with the victim. That means you can be around each other, but if voices get raised, it's a violation of this court's order, and that would be a new charge. If hands get raised, something gets thrown, it's a violation of this court's order, and there would be a new charge. Also going to allow you to return to your residence. I will remind you that it's the 21st century. Being outside of the jurisdiction of the state of Florida doesn't do a whole lot to, keep you from getting in trouble if you're not responsive, meaning come back for court appearances, make sure you're engaged in this. Do you understand all that?
Yes.
All right, bond is in the amount of $1,000, no hostile contact with the victim. That would conclude the matter. Yes, ma'am. Could you state your name, please?
Elijah Parker.
Mr. Parker, we're here because it's been alleged that a crime has been committed, that being specifically battery with domestic violence. You have the right to remain silent. You have a right to a trial in this matter. If this proceeds, you also have the right to counsel. I'm appointing an attorney to represent you. I do find that there's probable cause. So we've got two matters. There's the battery domestic violence and the fact that this gentleman is on bond for resisting without violence and battery, if I'm reading that right. In the battery, the new charge, I'll issue a bond of order a bond of $500, no contact with the victim. And I mean that, no contact with the victim. No return to the scene. Do you reside together?
Yes, sir.
Okay. I'll allow one visit with law enforcement to gather belongings. This is not necessarily forever. I don't know what your future holds, but while this case is pending, that's the order of the court. You're not to possess firearms, other deadly weapons, or ammunition while this case is pending.
Your Honor, would this case, the Department of Children and Families was notified? Based on that, would the court consider including a provision that the defendant must comply with any conditions imposed by DCF?
I know that that's a common request, sir. I see due process difficulties in that. Certainly, so no. No. I'm not going to order that, although one might suggest that that's a wise course of action. As to The fact that this gentleman is on bond, is there a recommendation or a request from the state?
No, Your Honor, I looked, the battery aspect of it was not a battery on a family member or domestic violence account of battery, I believe related to the resisting.
Court will take no action on that matter, the bond in the other case. That would conclude the matter. Sir, would you say your name, please?
Cecil Filbert.
All right, Mr. Filbert, we're here because it's been alleged that you may have committed a battery with dating violence. You have the right to an attorney. I've appointed an attorney for you. I've found probable cause in this matter. Court's inclined to order a bond of $1,000 in order no contact with the victim. Are there any other issues? If not, that would conclude the matter.
Your Honor. Call us in 2 weeks.
Would you state your name, please?
Elijah Tillman.
Mr. Tillman, we're here because it's been alleged that a crime has been committed, specifically battery with domestic violence. You have the right to remain silent about that. You have the right to be represented by counsel. I'm appointing Public Defender's Office to represent you. I've reviewed the sworn affidavits in this matter. I do find that there's probable cause. Court is inclined to order a bond of $1,500. Order no contact with the victim while this matter is pending. Do you reside together? You do?
Yes, sir. That's
I would allow you to.
my wife.
All right. Well, this is not forever, potentially, but for now, I need to make sure that potential victims of crime are kept safe. That's why I'm ordering no contact. You'll have to find a different residence. I will allow you to return home one time with the assistance of law enforcement to obtain your belongings.
Yes, sir.
Bond is $1,500, no contact with the victim, no return other than that one time. You're not to possess firearms, other deadly weapons, or ammunition. That's the order of the court.
Thank you, Your Honor.
Thank you.
Sir, would you say your name, please?
Anthony Galloway.
All right, Mr. Galloway. Is your date of birth July 12th, 1981?
Yes.
We're here because there has been allegations made that crimes may have been committed. Before the court today, let me see. Hang on. I want to make sure I understand correctly. State, I've got failure to appear. Which is the new charge? Which is the new law?
Possession of cocaine, grand theft, third degree.
Okay, all right.
And then I have a warrant served on a Dwillis.
Okay, thank you. All right, sir, it's been alleged that the crimes of possession of cocaine and grand theft of motor vehicle, you're presumed to be innocent. You have the right to remain silent. You have a right to counsel. If I've not already mentioned that, an attorney is appointed to represent you. I do find probable cause as both counts 1 and 2, possession of cocaine and grand theft. The court would order bond in the amount of $1,000 for count 1 and $1,000 for count 2. As to (2022) CF 011073 AO, on which you are on bond in the amount of $5,000. Court is revoking bond. Does the state have any suggestion regarding that matter?
The original bond was 5,000?
Yes, sir.
The court, we asked for bond be set, I believe it's 7,500, would that be 1.5?
Defense, do you wish to be heard?
Your Honor, he's already indicated he's not gonna be able to afford the bonds on the new charges. I just asked the court to consider his financial means.
Thank you, sir. I do consider the argument. I've read the affidavits carefully. I've made sure that I ask questions at the beginning of this, so I'm very clear on what I'm dealing with. I will set bond in the amount of $7,000 after having revoked it on the previous case. So, Madam Clerk, that's as to 22 CF 11073. That's the order of the court. The matter is concluded.
There's another, case. Excuse me, there's another case.
I apologize, sir. All right. As failure to appear, you have the same rights as to any of the other matters. I will find probable cause that's based upon a lawfully issued warrant in which a judge has already found probable cause. Set bond in the amount of $500. That would conclude the matter. I'm reducing it. Yep, 500 is less than 2,000.
You got bonds on everything.
Sir, would you say your name, please?
Jenkins.
We're here because an affidavit has been filed alleging trafficking in certain controlled substances under Florida statutes 893.135, subsection 1K. You have the right to remain silent today. You also have the right to have a counsel present. I've received your affidavit. I will appoint counsel to represent you. I have found probable cause, and I have considered the amount of bond. I will let each of the parties be heard. Does the state have a recommendation or a request?
It's a standard amount, it seems appropriate. It indicates here that he's a violent felony offender of special concern, but I'm not sure if that would apply in this situation, since it's not the bond aspect of it would apply, since it's not a violation of probation.
Okay. I've heard from the state. I will hear from the defense, if you wish.
Your Honor, just that this is from a defense perspective, a great trial case. This wasn't his vehicle. There's multiple people in the car. This is a constructive possession theory of prosecution that the state's gonna have to somehow overcome the judgment of acquittal based on the fact that this drugs weren't in plain view. There's nothing to indicate my client had knowledge of the drugs. This is further evidenced by the fact that this wasn't his vehicle. And again, the surprise and his statements that he made to law enforcement. He waived Miranda, he expressed to law enforcement that he's not the registered vehicle. He didn't have any idea about what was in the car. What I think is very important to what he was saying to the officer is that he said, hey, any drugs in there, there's gotta be a prescription. Meaning he had completely no idea what was going on in that car. He thought the officer, if he had found anything, it was prescription pills. Based on that, Your Honor, and again, this is a very, very, very defense-friendly case. We'd be asking the court to set the bond accordingly, an amount that he would be able to afford. He already expressed to me that $50,000 is way too much. The court would consider setting the bond in $5,000. I believe that's something he'd be able to afford.
Well, I've already found probable cause, but it's not within the four corners of the affidavit. Did the state ever verify ownership of the vehicle?
Judge, I would know nothing, I would have no knowledge outside the four corners, even if you could consider it. I don't know anything.
All right, sir. Okay. Well, this may be a defense-friendly case when subjected to the very stringent burden of beyond a reasonable doubt, but I do order bond in the amount of $50,000. That would conclude the matter. Thank you. All right, I'll hand this over to you, clerk.
Okay.
Sir, would you say your name, please? Sir, we're here for the first appearance. It's been alleged that the crime of grand theft of a motor vehicle, that's what's being alleged. You have the right to remain silent. You have the right to an attorney. I do have a financial affidavit. You do not qualify financially for the appointment of counsel. However, I'm going to ask the Office of the Public Defender to appear on your behalf today. After today, you're going to have to revisit your financial affidavit, make sure that you filled it out accurately, or hire your own attorney or make other arrangements. For today's purposes, I have reviewed the documentation. I do find that there's probable cause. Court's inclined to grant bond in the amount of $1,000. Is there any other issue? That would conclude the matter. State your name, please.
Jonathan McCray.
All right. It's not my intention to interrupt you from speaking to your counsel. So if counsel says that you need a minute, I will grant that. So we're here today on a failure to appear charge. You have the right to remain silent and the right to counsel. Counsel's been appointed to represent you. I do find that there's probable cause. Is there a recommendation by the state?
No recommendation, Judge.
All right. Court's inclined to grant a bond in the amount of $150. You got two failures to appear?
No, it's one. A judge speaking, it was a case and she issued a low bond. I'm sorry, Judge.
Yeah, show me. Stand by.
I'm sorry. She was do not. She did. She was presiding.
I did read that.
We don't say it on there. Just leave it out. You said it.
I did, well, my note says that. I said 100. And this is a year old. Okay. Okay. All right. No changes to the court's order. 150. Correct, but I said 150. Would you state your name, please, sir?
Michael Costello.
Okay. I'm out of order, Madam Clerk. I had, what status of Alejandro Ramirez? Thank you. All right, this is Mr. Costello. So we're here because it's been alleged that that you've committed the crime of trespassing in an occupied structure and refused to leave. You have the right to remain silent. You have the right to an attorney. I've appointed counsel to represent you. There is an attorney standing to your left. I do find that there's probable cause regarding this count. Court's inclined. Are you, do you have a home, sir?
I'm trying to move, and that's why I don't have a home. My lease ended in the place I got in Orlando because it flooded, and after 3 weeks, they refunded my money, so I'm in a hotel. Or was in a hotel.
All right, I'm going to order, first of all, I'm going to order no contact with, let me see. There was a front desk person at the extended stay facility.
Would you like her name?
I believe it's Taya Ward, is that right? I'm going to order no contact with Taya Ward, no return to the extended stay facility. I'm going to order bond in the amount of $500.
Your Honor, all of his possessions are at the extended stay. He's actually worried about having to post the bond. He doesn't have any assistance with that. The court considered non-monetary terms of release, and then he's going to need a one-time return to that extended stay.
Are you working, sir?
Yeah, I was going to get a new restaurant job. I've worked bartending and waiting tables for a long time, but I was in the process of moving to Orlando.
Well, as I stated earlier, this is, you have a presumption of innocence. I don't know what is true because it hasn't been tested with evidence. I will say this, if there's anything in this affidavit that is accurate, it's unacceptable. It's unacceptable, and it's behavior that needs to change. Having said that, I will release you on your own recognizance with the following conditions. So I'm rescinding the $500 bond. You have to check in with the public defender's office, with someone who you will develop a professional attorney-client relationship with at least once per week by the end of the day each Friday. Public defender and the state attorney's office are advised or directed by this court to cooperate with one another on the sole issue of whether or not the gentleman is living up to that court order. I will allow you to return to the extended stay. So like, are you like paid through the next week there or something?
Yeah, well, yes, but that's.
All right, well, you're gonna have to leave, but you'll be allowed to return to gather your belongings in the company of law enforcement.
Thank you, Your Honor.
Thank you.
All right, that would conclude the matter.
Don't report to the PD
Weekly.
on Friday.
Well, before Friday of each week. Mobley. Okay, the next, hold on.
I had Horger.
I'll impose $1,000. Any other issues?
No, Your Honor.
All right, thank you.
That's the blank.
Mr. Brown, would you state your name, please?
Terrell Andre Brown,
What's your date of birth?
2688.
Thank you for your patience this afternoon. We're here because the court has received an affidavit that alleges a criminal act, specifically aggravated assault with a deadly weapon. You have the right to a trial on this matter. You have the right to remain silent. You also have the right to have an attorney present for you. I'm going to appoint counsel. If you need a moment, I'll give you a moment. That's fine. I will, court's inclined to find probable cause and follow the recommended bond amount of $2,500 or $2,500. I'll give you a moment to speak with your attorney.
Okay.
Your Honor, he's indicated he should be able to afford the $2,500 bond.
All right. Thank you. If there are no other issues, that would conclude the matter.
Yeah, awesome. We'll get an attorney, see, I don't know who it's gonna be. It might be me, I don't know.
Hello, sir. Would you say your name, please?
Justin Joseph Raymond Fout,
And your date of birth?
June 25th, 1993.
We're here, sir, because the court's received paperwork, specifically a sworn affidavit. Hold on.
He's out of bond.
He's out on bond now?
Yes, I don't know.
Oh, that's a previous one. Okay.
Sir.
All right, counsel, help me out.
Sir.
All right, so we've got okay, so the previous charge, and the court is not making any findings or opining about guilt or innocence. But prior charge, grand theft, third-degree theft of a motor vehicle, 9908.
He's out on bond on that, yes. No, he's out on bond on.
It's 8584, yeah.
Got it. All right. Okay, I read the inmate number. My apologies to everybody. This is grand theft of a fire extinguisher. Have I got that right?
Yeah.
Okay. All right.
Can I tell you everything that happened?
No.
Your Honor, please.
Well,
Please, can you hear me?
I do hear you. Listen to me now. I can't give you legal advice, so I probably can't answer the questions that you have. If you want to try to start explaining things to me, you'll be giving up a lot of significant rights, and you won't be giving me a full presentation probably of what you want me to hear. So I certainly respect your desire to be heard, but I would defer you to your counsel about that, and I suggest that you follow his advice.
Serious, can I talk, please?
Go ahead, go.
So, everything that happened yesterday was me.
Swear in the defendant, please.
Right here. You solemnly swear for the testimony shall give me the truth, the whole truth, but nothing but the truth?
Yes.
And I'd like to put on the record, I'd advise my client not to speak about the facts of this case.
Okay.
Okay.
Well, I just made him a promise. Be brief, please.
Okay. Yes, sir.
And I will note this is against your attorney's advice. All right, sir.
Me and my fiance, we was on a bus going down 441, going towards Apopka, and I was denied. I could not get off of the bus at the bus stop because there was 3 individuals telling me that it was okay for me to die, that I would be happy, and I was scared. I was scared, sir. So we had to go on down further, and we came to an apartment complex that there was a bus stop at. That it's just crazy, Your Honor.
Okay.
There was kids yelling and screaming, and I didn't want to walk down the road by myself. It was a whole bunch of stuff, and me and Christina had the fire extinguisher, sir.
Okay.
So that we could protect ourselves from anybody. Because
I
I
hear
feel like
you.
the kids are being kidnapped.
I'm gonna cut you off, and I don't mean that disrespectfully, because I was the one who said you could speak.
Yes,
I
have so
get the gist of it. I get it.
I do not need to be in jail, sir. Please. I do not. I have a family at home waiting for me. My wife came down here to jail. I didn't do anything wrong at all. I called the police last night. I had the police call. I was begging for help.
Okay. All right, is there any issue from the state, or do you wish to inquire based upon the gentleman's statements?
I mean, he just admitted to the crime, Your Honor. There's PC.
It was so cold last night. It was 35 degrees, sir. And my wife had to get admitted to the hospital because the officers kept her outside on the ground for like 3 hours. We didn't do anything wrong. We was just begging for help.
I would point out, As far as strength of case is concerned for the state attorney, Your Honor, this is a necessity defense all day. My client is very convincing that he felt he was endangered.
Well,
And
it's-
that's something we'd be able to rely on
It's
later.
the court's own fault because I invited it, but you both know we're not getting into that today.
Can I please,
What I'm struggling with is that, all right, the gentleman was already on probation.
No, sir, not
Theft of a
probation.
motor vehicle, correct?
Yes.
We're out on bond, sorry, out on bond.
Innocent.
I mixed terms, my apologies. Gentleman's released on his own recognizance. Probable cause is found.
Thank you, sir.
That will conclude the matter.
Your
Go.
Your Honor, are you taking any action on his out on bond case?
No, I'm not.
Thank you.
Sure. Go.
Hey, you gotta, you're doing good, but keep that up, all right? Not good, you gotta rest.
Could you say your name, please, sir?
That is Grant.
What's your date of birth?
11/13/1982.
All right, sir. We are here. We're here for a first appearance. The court's received an arrest affidavit that alleges certain criminal acts. I think I've got 5 counts. Substance possession, carrying a concealed weapon, possession of weapon by a felon, 2 counts of that, trafficking in cocaine. Sir, you enjoy the presumption of innocence. You enjoy the right to a trial as well as the right to remain silent.
Yes, sir.
I'm appointing counsel to represent you. There's an attorney standing to your left. Is there any argument regarding probable cause or challenge to a finding of probable cause?
Not at this time, Your Honor.
Court finds probable cause as to all 5 counts, having reviewed the sworn affidavit. Court is inclined to impose the bond amounts as recommended in the arrest affidavit, but I will give the parties opportunity to be heard on that if they wish.
Your Honor, Mr. Grant indicated to me that at a maximum, that's going to be getting help from family members, that across the board, he can afford a $5,000 bond. What? He can't touch the writ. I told that to you back there already.
Oh, what?
No, I already explained that. Right. So, Your Honor, we'd be asking for the court to consider setting the bonds in the amount of $2,500 on the highest count, I believe would be the trafficking, and then subsidiary bonds thereafter. That would not completely deplete all of his savings, or his family member savings.
Does the state wish to be heard?
At this time, Your Honor, the state would request that we follow the recommended bond amount. If there's a bond hearing at a later date, then so be it, but the seriousness of the charges are clear from the charging affidavit and the defendant's history.
And I don't have his history available. I do
I'm not-
show his risk assessment was low, though.
Yeah, I do note the risk assessment being low. Well, it's subject to modification by the trial judge, certainly, if there are important mitigating or other factors. But the amount recommended in the affidavit, particularly for the highest level offense, if you will, count 5, is at the low end of the tables. So I will find probable cause as to all 5 counts. As I've mentioned, I will issue bond, or order bond, rather. Count 1, $150. Count 2, $150. Count 3, $150. Count 4, $150. Count 5, $50,000.
And he does have an additional case, Your Honor. It's a misdemeanor possession of drug paraphernalia.
Thank you, ma'am. All right, I'll find probable cause, appoint counsel. I'll issue an additional bond amount of $150 for that charge. Any other issues?
No firearms, weapons, or ammunition, correct?
Well, given that the allegation was possession by a felon, the court shouldn't have to say it, but yes, granted, no possession of a firearm or ammunition while this matter is pending. All right, sir.
Sorry, thank you, Your Honor.
All right, take care. So this means, catching on. Mr. Gray, would you say your name, please?
Kevin Gray,
What's your date of birth?
March 8, 2003.
I've got an affidavit, hold on, maybe I missed something. I've got an affidavit for the case that he's currently on bond for.
He has two cases out on bond, Your Honor. He's in on 14823.
That's not.
So what is our new charge?
He's now charged with carrying a concealed firearm and resisting without violence in 22 CF 014823 AO.
Okay.
Defense has a probable cause challenge to the concealed firearm.
All right, proceed, please.
Where in the affidavit does it state that the firearm was concealed and a waistband was concealed in any articles of clothing? It just merely states that my client was being pursued by law enforcement and that the firearm was found, or that it fell. And the second firearm was in plain view, that speaks for itself.
Say that again?
Second firearm was in plain view, therefore it cannot be concealed.
State have a response?
I mean, Your Honor, it states right here, as Gray Jr. continued to run, he dropped a handgun. If we want to reset this, I can have the officer write a supplement, but he doesn't make any mention of seeing a handgun before, and then it falls from Mr. Gray's person. So unless he was holding it in his hands, it had to be concealed.
You want to hold this whole thing over? Because,
I mean, the state's of the position, there's PC, but if we're gonna reset this,
within, all right, I will say, and respectfully, with your very good argument, in the four corners of the affidavit, I think there's something missing as to that count.
as to the count of a concealed
Yes.
firearm?
You had suggested that it would not be difficult to get a supplemental.
Well,
I'm willing to grant time to do that.
What do you feel is missing, Your Honor? A statement by a police officer stating that,
Context, and I don't want to get too much into it because I'm not equivocal about this. Somebody could have run up and said, "Hey, dude, we're being chased. Hold this." I mean, I've got nothing before a firearm was dropped. And I'm being asked to make an assumption that it had to have been taken from a pocket or other sort of container prior to being dropped, and it's simply not there. Reasonable minds can disagree, sir. But I'll I'll reset this for tomorrow to hear a supplemental. We'll take up the entire matter.
I'd like to express that he's employed, he works at Advent Health, he's also enrolled in college.
I'm a nurse, I'm an assistant nurse, and if I miss one more day of work, I will get fired. I worked so hard to get right there. I graduated literally this year to get me right there. And I already called off today. Is there anywhere I can get to work? I have my bond money.
Okay, no, and I'm not trying to be rude to you, sir.
Please, bro, please. Like, I worked so hard to get this job.
Well,
if I miss one more day and I'm literally fired and I can't go to my college, I got an offer, literally. I start college January. I also have a kid on the way.
Well, what's being requested is,
and one more thing, my brace.
Okay,
I'm listening.
What's being requested is a bond amount of $4,000 plus $100 on the new charge, and then the court has to take up what to do with the fact that you were already on bond for resisting an officer without violence, whether or not to revoke your bond on that matter.
I will pay double if I have to. Please help me out, please.
He also has a second out on bond, Your Honor.
What's the request? I'm sorry?
He also has a second out on bond as well, Your Honor. He's also up for a robbery, sudden snatch, and a grand theft third degree.
Lee, and then one more thing also, my braces bracket, when I fell to the floor from the officer, my braces is literally stabbing me in my gums.
So,
please, bro, please, like, just help me out, please.
It would beg the question why someone with so much at stake regarding employment and education just stop.
Sorry.
I'm not inviting comment. This is rhetorical. It begs the question why one would engage in behavior risky enough that would cause police to be chasing you while you're holding a handgun. If the gentleman withdraws his challenge to probable cause, I'll set bond.
Okay. If we withdraw our challenge of probable cause, we're stipulating to there being enough evidence for them to have arrested you on the concealed firearm charge. Are you okay with that?
So what does that mean?
It means that the judge is going to set a bond, but then he still has to make a determination on whether he's going to revoke these bonds or not. But that's your call.
What you think I should?
It's your call, dude. I don't know. I told you what to do already, and then you said you wanted to ask for bond here, but we.
Is there any way I can ask you what's the best for me to do?
No.
I don't even.
Your Honor.
It's an understandable question. The answer is no. I cannot give you advice.
They both have their flaws. They both have their pluses.
So-
If I were you, I would have challenged the probable cause on this other charge because I don't know what the judge is going to do on these other charges that I'm out on bond on. That's what I would do, but it's your call.
I'm sorry.
So if I do the other.
I'm allowing.
Would I be able to get out today?
Okay, well, I'm going to go with the recommendation. I'll find probable cause. I'll go with the recommendation of $4,000 count one, carrying a concealed weapon, $100 count two, resisting an officer without violence. As to court does not want to appear to be punishing a gentleman for exercising his rights to challenge. So court will reserve.
Taking no action on the two?
Taking no action on the two bonds. That's it. Next case. Would you say your name, please, sir?
Richard Walter Herbert.
Did I passed right over this, sorry. What's your date of birth, sir?
26, 1978.
Sir, we're here because the court's received an affidavit that alleges certain criminal acts. Let me make sure that I've got these, don't have these backwards, because you're currently on bond for motor vehicle theft, correct? Okay.
That's correct, Your Honor.
Say again?
That's correct.
Thank you. Current charges that we're dealing with today, sir, are driving without a valid driver's license. And is this this is again another grand theft in the third degree?
That's
Okay.
correct.
All right, thank you. Is there any challenge to probable cause?
No, Your Honor.
Court finds probable cause. Court's inclined to order the recommended bond in the amount of $2,500 for count 1 and $1,000 for count 2 as to bail on case number 2022 CF 14824.
I don't know why they write the case number up here, but it's actually in here. This is the case that he's saying it. So tomorrow, I'm gonna let him do that.
Thank you very much. Court's apologies for misstating 2022 CF 013134. Is there any request for relief from the state as to current bond status on that matter?
We'll leave it up to the court's discretion, Your Honor. We would at least argue an enhanced bond higher than the original bond set due to him touching new law offenses.
All right. The original bond was 1,000 in that matter. The offender, sorry, you're innocent until proven guilty, sir. The defendant is accused of committing the same act, essentially being, at this point, if true, court begins to suspect a fairly routine enterprise. So bail in 2022 CF 013134 is revoked and reimposed in the amount of $10,000. Next case, please. Would you state your name, please, sir? All right, Mr. Hightower, what's your date of birth?
1967.
We're here, sir, because the court's received an affidavit that alleges certain criminal acts, in this case, petty theft. There's only one count, correct?
Yes.
There's a resisting.
There's two
case as well.
cases.
Okay, thank you. On the page I was looking, there's one count, you're correct. So, as well as an additional affidavit, sir, of resisting an officer without violence. You have the right to remain silent on these matters. You have the right to go to trial on these matters if you wish. You also have the right to have an attorney appear on your behalf. If you cannot afford one, one will be appointed. I do see that you filled out a financial affidavit. I will appoint counsel to represent you. Is there any challenges to probable cause on either of the arrest affidavits?
No, Your Honor.
All right. Bond amount is recommended at $500 each, and independently, the court's inclined to grant that. Can your client afford that?
One moment, Your Honor. Into a bond, Your Honor. Would the state be willing to make an offer on the resisting without violence? He said that he could afford a $100 bond. He would like to see if he could enter a plea onto the resisting and then post the bond on the petty theft to prior.
I won't make suggestions about what the state should or shouldn't do, but could you answer the question?
State will offer adjudication of guilt, court cost, credit time served on the resisting officer.
Your Honor, he would like to accept that offer.
You have form for the court, or will you shortly?
Yes, Your Honor, if we can roll him.
Okay. If we're able to accommodate keeping him standing by, I'll do that. So, we're going to recall the resisting without violence matter. Did I already hand it to you? No, I did not. As to the petty theft, bond remains, that is a separate order. Bond is $500. That matter is concluded. We'll recall the resisting.
Return to the scene on that petty.
Yes, ma'am. Thank you. All right, so. Sir, would you say your name, please?
Garris Antonio Hilton,
What's your date of birth, sir?
6287, sir.
All right, thank you. We're here because the court's received a sworn affidavit that alleges you may have committed certain criminal acts. There are seven counts. One is possession of cocaine within 1,000 feet of a conveyance or bus.
I had a probable cause challenge on
Okay.
that.
All right. Count 2, possession of methamphetamine. Count 3, possession of cocaine. 4, attempted destruction of evidence. Count 5, possession of cannabis, less than 20 grams. Count 6, possession of drug paraphernalia. And 7, littering. There's been a challenge of probable cause on at least one count. You may proceed, sir.
I also have a challenge to the attempted destruction of evidence, which I have case law, and I can read the site for the state. It's 25 Southern 3rd, 625.
Yes.
Can I get that case law one more time?
That case stands for the proposition that merely dropping or abandoning drugs in front of an officer does not constitute attempted destruction of evidence. When it's done in plain view, all it is considered is abandonment. As far as the possession of cocaine within 1,000 feet of a business, there's no evidence that they were within 1,000 feet in the affidavit.
The officer states that he was on the sidewalk directly in front of the business.
Right. I don't know how far that sidewalk is from that business, Your Honor. Right. Right.
All right, just a moment. All right, thank you. I've considered argument, I've considered 25 Southern 3rd 65 EI versus State of Florida. We'll remind the parties that probable cause is very low threshold. I do believe that EI versus State is distinguishable on ways that could be relevant to the issues before the court. The appellate court in the second district relied upon, in more than one location, in the term clear sight, which relates back, as I read this, to the actions and intent of the defendant, not to the officer. In other words, this carries with it the flavor that defendant intended to abandon, not destroy, but abandon the substance knowingly in clear sight of an officer. In this arrest affidavit, we don't have the same thing. There's no suggestion that the defendant knew that he was being observed while he was dropping the red baggie and other objects.
So, Your Honor, is that not finding for probable cause?
No, I am finding probable cause.
If he didn't know law enforcement was observing him, then surely that's not evidence that he was trying to, that's even more to the point of he's just dropping whatever's in his pocket. If he didn't know law enforcement was watching him, then he's just littering at that point.
What I'm going to, and perhaps the court stated it inartfully, and that's a good observation, counsel, goes, and we're really getting into the weeds here, but it goes to basically in intent. Again, this is not a trial. This is a probable cause determination. Court's not heard, other than the four corners of this, any sworn testimony. The circumstances under which the person in the car in the case law seems to have gotten rid of the objects versus the circumstances in this case, I think are distinguishable. Whether or not the gentleman knew that he was being observed. All right. As to possession within 1,000 feet of a conveyance, the plain meaning of the English language words here more than strongly suggests that the affiant meant to say that he was adjacent to or close to a business under the normal meaning of words. So I find probable cause as to the 7 counts.
Your Honor, my client doesn't have the financial means to post bond. We'd be asking for the court to consider non-monetary terms of release in this case. I would point out that it's grossly overcharged as far as his officers, whatever he's attempting to do. As a citizen of Florida, this is upsetting to me that he's trying to stick 7 felonies for the simple possession of 1 bag of methamphetamines. The possession of cocaine is based off residue that was scraped off a pipe. The cocaine possession within 1,000 feet of the business conveyance. I mean, it is what it is, Judge, but this is clearly being overcharged. This is clearly a waste of the state's resources. In the interests of judicial economy, we'd be asking the court to release my client on non-monetary terms of release.
State wish to respond?
Based on the history, Your Honor, we understand the financial aspects. We would be okay with lowering count 1's bond, but as to no monetary bond whatsoever, the state would disagree.
All right. All right, counts 2 through 7 shall remain, well, I haven't ordered anything, so they don't remain. I'll reduce, the court doesn't see within this affidavit any suggestion that any of this was for other than his own use. I don't know one way or the other, but within the 4 corners of the affidavit, count 1's bond will be $2,500. Count 2's $150. Count 3, $150. Count 4, $100. Count 5, $100. Count 6, $100. Count 7, he's released on his own recognizance.
They still have to. We might be able to get you on the bail project. We can apply you to the bail project. We gotta talk to your attorney about it first, though, okay?
All right, we need to move along, gentlemen.
We'll talk to you later about it. They might be able to help you with that. You're good. Huh? Release on your own recognizance. Only on one, though. You have bonds on the other ones. We got to talk more later, okay? Who talked to you?
I know how you talk to them.
All right.
What? Yeah.
Mitchell, will you state your name, please?
Say your name.
Amara Mitchell, sir.
And is your birthday July 23rd of 1997?
Yes, sir.
All right, we're here because courts received information that allege crimes, specifically felony murder and third degree, which would be third degree murder, robbery, armed with a firearm, wearing a mask. You are presumed innocent. He seems quite surprised. Am I reading something incorrectly?
No, Your Honor.
No, that's.
Okay, all right. Listen to me, sir. You are presumed innocent until proven otherwise. You have the right to remain silent. You also have the right to trial. I'm going to appoint counsel to represent you. Are there any challenges to probable cause?
No, Your Honor.
Court finds probable cause. This gentleman was already on bond, is that correct?
That's correct, Your Honor, in Osceola County.
Osceola, Your Honor.
Osceola.
Right. All right, what, if any, relief is the state seeking?
Your Honor, this is a punishable by life offense. The state is going to be requesting no bond.
Okay. I'm not precluding counsel for the defense from making argument, if you wish. The court is inclined to order no bond.
Your Honor, my client's indicated a maximum that he would be able to get together is $3,000 worth of money. You don't, that's not your money, right? It's someone else's.
My mom's.
Okay. From his mother, I'd ask the court just to consider that in setting terms of release, as well as the presumption of innocence. As far as my reading of the affidavit in this case, it came from an anonymous tip. A lot of the connections for Mr. Mitchell, which again, those need to be explored further, but it looked a lot like the officer was just relying on the fact that one of the individuals involved in the robbery was wearing a white tank top, and then he allegedly saw images of my client wearing a white tank top later that day. He said, the officer said something to the effect, and that also led me to believe that Mr. Mitchell was involved. I mean, a white tank top is pretty generic. There is a second, I guess, portion to the officer's belief is why my client was involved, because he showed up in an apartment with some other alleged co-defendants. But again, this happened after the alleged fact. When I was reading the affidavit or in the arrest warrant, I didn't see anything that was directly tying my client, other than, again, we had these anonymous tips. And then the tank top situation with the two individuals, one who was allegedly wearing a mask. But other than that, Your Honor, he deserves his day in court. He's veiled in the presumption of innocence at this time.
Your Honor, briefly, two things. PC has already been established by the arrest warrant that was filed by another judge. Secondly, it is a punishable by life offense. He's not entitled to any bond at initial appearance. If they want to have an Arthur hearing down the road to establish bond, then so be it. But at this point, he's not entitled to bond.
I will stress again, because it is true, the gentleman enjoys the presumption of innocence. However, public safety is part of this, part of all of this. Court will order no bond.
Right.
We can get one, though. We just have to have a hearing downtown, okay?
And,
You're gonna get a really good.
and Your Honor, with the out on bond, are you taking any action?
Yes, no return to the scene, no contact with the alleged victim, no possession of firearms or other weapons.
No, with the out on bond, Your Honor.
Say again?
With the out on bond case from
It's
Osceola?
Already found.
It's revoked,
It's
set at
revoked.
none?
Yes.
And that's the problem.
It's like a.
All right, I know the gentleman is not pleased, but we do need to move along. That would
Like I
conclude
said,
the matter. Good afternoon, sir. Would you be kind enough to state your name?
Perry Rowe,
What's your date of birth, sir?
June 26, 1979.
Sir, we're here because there's been an affidavit filed that alleges certain criminal acts, burglary of a dwelling or structure causing damage, criminal mischief, possessing burglary tools with intent to use, and theft.
I have probable cause challenges to counts 1 and 2.
All right, go.
There's nothing to indicate that $1,000 worth of damage that was done. The only thing that talks about money is that my client had $854 in his pocket. There's no assessment from the alleged victim saying, hey, this is how much copper / metal / whatever was in that building got destroyed. It's just simply not enough information, Your Honor, to make the conclusion that $1,000 of property was destroyed for both the burglary of a dwelling with $1,000 in damages and for the criminal mischief over $1,000.
Right, the court does find probable cause. Say again? Yeah. Bond is stayed as, at $5,000 for count 1, $150 for 2, and 3, $100 for count 4. No return to the scene of this particular allegation. That's all.
Thank you, Your Honor.
Right.
Call us in 2 weeks, okay?
Payola Rihanna was a bond?
She bonded?
Bond.
All right.
Post the bond. It'll be 500 to the bondsman.
I'm fine. Thank you. Sir, would you state your name, please?
You don't. Civil. Say your name.
Would you say your name, please?
Dennis Silva.
Okay. Are you able to hear me okay?
Yes.
All right. What's your date of birth?
September 30, 1999.
All right. So we're here for a first appearance because there's been an affidavit filed that alleges failure of defendant to appear in driving while license suspended or revoked, and possessing no valid driver's license. You have the right to an attorney. I appoint counsel to represent you. I find probable cause. Are the parties wish to be heard on any other issue?
If I can just briefly, the state attorney conveyed a plea offer to resolve all of his outstanding cases. I wanted to talk to him about it. Do you want to get your cases resolved today? Or did you want to postpone? What?
I'm gonna take my license.
You're gonna get your license? Okay. If, in this type of situation, in my experience, when they're able to get their license, often the state attorney drops the charges. He indicated that he wants to get his license. If we can have terms of release that would enable him to do that.
Okay.
Ms. Court, you got it, right?
What was the, what did he fail to appear for?
Driving while license suspended and a no motor vehicle registration, I believe, Your Honor.
All right.
That's correct.
All right. All right, so I'm dealing with how many counts?
It's 3 different cases.
3 different cases, that's why,
Yes,
yeah.
3 different cases.
All right, as to, I just, for some reason, I seem to have 2 precise copies of the same failure to appear. I think these are identical. No. Yeah, all right. Mm-hmm. Correct. With no what? Right. All right, I'll find probable cause as to all these matters. As to the 2 failures to appear, I'll reduce the $1,000 bonds to $500 for both of them. As to the new no valid driver's license, also $500 bond.
Thank you, Your Honor. Amen.
All right. So,
License back. This is costing you.
all right, next case, please.
Jonah Parker was a bond.
That's your number 1 goal, okay? Go get your license.
Jonah Parker's a bond, thank you.
Okay. What are you charging?
All right, sir, would you state your name, please, and your date of birth?
Franklin Morales.
Okay, you're here because it is alleged that you've committed the crime of driving without a valid
Negative.
driver's license.
No, that's a different person, Your Honor. This is Moralt. He's been on a trespassing and a drug paraphernalia.
Okay.
What did happen to Melvin Ramirez Gutierrez, though? Is that what you were looking at, Your Honor? The no.
That is what I was looking at, yeah.
Do you have a booking number for them, Your Honor?
Let me hand it to you.
The booking number is 22029909.
They bonded out.
Thank you.
So is this Mr. Morales? Okay. If any confusion was caused a moment ago, it was certainly not intentional. All right, these are serious matters, sir. We're here because there's been an affidavit filed that alleges trespassing and possession of drug paraphernalia. You're presumed to be innocent unless proven otherwise. You have a right to remain silent. You also have a right to counsel. I will appoint counsel to represent you. I do find probable cause. Unless I hear objection or other argument, the court will impose $250 bond for count 1, $500 bond for count 2.
What?
All right.
Your Honor, the state-related adjudication credit time served court costs no return offer. My client indicated he wants to take it. Unfortunately, we have 1 plea form, and I was saving it for that other guy.
There are copy machines in this building.
All right, so, you want to accept that? Yeah.
We will pause, well, not at the moment, we're going to recall it, but it is in the best interest of justice that we resolve the matter.
Are we released today now?
What?
Are we released tonight?
Yeah. I gotta go
God, you
make copies. Your Honor, may I be excused?
Well, if I'm going to recall this, I'd rather just handle it at once. I'm not trying to be a difficult counsel. If we can continue, I'll recall this and then give you the time to go take care of the forms for this and the other plea.
It should be some in the office.
I thought the clerks had plea form.
I mean, you're supposed to go in there and get them yourself. It's not for us to get them.
Well,
But I can go get some if you want me to go get them, if the judge give me a minute to
Okay,
go
I'll get
recess.
them, I don't care.
all right.
Whatever.
Court's in
makes the most
recess.
smooth.
It is, the court acknowledges it's not the clerk's
I'm not going-
responsibility.
It's okay, Judge. He said I was being really rude. Let him go get them. I'm not going.
What?
I'm sorry,
Okay.
Judge. He can go get them.
Do you have a way to get copies done?
Apparently they're in the other courtroom. I'll run and go, whatever's smoothest. I can make this happen now. I want to move this along, so.
All right, court is in recess.
Or else is who we are on right now.
Right, that's going to be recalled.
Okay. So are we moving to Nicholas then?
We
Your
are.
Honor? Okay.
Next case, please.
We're moving.
Ariel's mental health, Your Honor.
How do you wish to proceed, counsel?
We could roll.
Are you
Your
appointed for him at all?
Honor. If we could roll that, Your Honor.
I'll call Mr. Nicholas tomorrow. Crystal Pacheco has bonded. Thank you.
You're rolling.
The one just before Pacheco, yes, and that will be recalled tomorrow. Oh, ma'am, would you say your name, please?
May Williams.
This might have been mixed from something else. What's your date of birth, ma'am?
June 2nd, 1998.
All right, we are here because there has been an allegation of assault on a law enforcement officer and resisting an officer without violence. You're entitled to the assistance of counsel. I will appoint an attorney in the form of the Public Defender's Office to represent you. You have a right to remain silent today, ma'am. Is there any challenge to probable cause?
No, Your Honor.
Court finds probable cause.
We were hoping for a plea offer. I don't know if the state would extend one.
Court will entertain one if there is an offer available.
I don't have one, Your Honor.
All right, I will, I'm going to order bond in the amount of $500 in count one and $100 in count two.
Your Honor, I would just put on the record, my client indicated she doesn't have the financial means to postpone. Nothing further.
Do you have any family members or friends who know you're here?
No, I'm in Miracle of Love program.
Yeah, Your Honor, I realized this defendant's name looked familiar. I have this case, the defendant's going through competency status hearings in multiple different cases amongst multiple different divisions. So I wouldn't feel comfortable extending a plea offer for her to accept
Not
today.
me either. She's not coming up in my system.
Yeah,
What's the,
I had her misdemeanor case at one point in Division
Right.
80.
No plea today, Ms. Williams.
what program were you in, ma'am?
Miracle of Love.
I don't know that I'm familiar with that. What services do they provide?
It's for HIV places that I'm homeless and stuff, and I'm getting stable there, getting a job.
All right. Are you working at all?
No, but I'm gonna start working.
Ma'am, what you've been accused of is serious. You can't, and I don't know what's true, and we're not going to talk about it now. But you can't just throw things at law enforcement. You can't do that.
I didn't actually
Hold
try
on,
to.
hold on. We're not going to talk about it right now. Are you under the care of any medical personnel? Do you have a psychiatrist or anyone you see?
No,
Have you in your adult life?
I think so.
Well, keeping this individual on bond that she cannot afford doesn't actually accomplish anything for the public.
Your Honor,
Yes, sir.
the state has no objection to ROR. She showed up to every single one of her competency status hearings. She's been deemed
Granted.
incompetent to proceed. It's fine with the state.
That would conclude the matter.
Do you want to do the plea? Is that you? No, you're different. Nothing. I know.
Sir, would you say your name, please?
Anthony Albert.
Did I skip over or misplace Martucci or Marcucci?
Do you have a booking number for them?
2202-9904.
They bonded.
Thank you. All right, Mr. Albert, we're here because the court's received an affidavit that does allege certain acts that, if true, would be criminal. You have the right to an attorney. I'm appointing counsel to represent you.
Understood.
Court finds probable cause. And we were here yesterday. I recall this.
Excuse me.
What do you want to say?
Say again?
It's a warrant. We'll get you a copy, but we're not, yeah, no.
22 CF 14806.
Here.
14806. Okay, understood. This was reset. All right, anything from the defense?
No, Your Honor.
Anything from the state?
No, Your Honor.
I'm sorry, Judge, I misspoke. I just said my client indicated he doesn't have any financial means to post bond in this case.
The bonds are already set at reasonable amounts per the charges, Your Honor.
All right, I do hope that the gentleman's financial situation improves. I will keep count one at $1,500. I'll stay the bond, 1,500, count one, 500, count two.
And Your Honor, he is out on bond. Are you taking any action on that? He's out on ROR. He was ROR ordered on December 19th.
That happened prior to, oh wait, no.
Just happened a couple days ago.
I don't have the actual copy of the warrant to show whether or not it's a 33-day motion.
What you mean 30-day motion?
Is that not what happened the other day? You had a 33-day?
No. I got the other day for resisting arrest. I didn't even come to court. They came down there and said I was released. This was like 2 or 3 days ago. They said I had a resisting arrest.
Right.
I'm not, I don't know,
Right.
nothing.
All right, I'm not revoking terms of release on the previous charge.
Yeah.
So he's still released to his,
I don't know what the facts are behind it.
no return to 7-Eleven. No return to 7-Eleven. All right, that would
Another
complete the matter.
case they said.
Reyes Centeno was medical.
This one, for resisting without violence.
That's not what I had up next.
Revoke.
Oh, Baez Tano, okay. We'll call that, we'll reset that for tomorrow.
I saw you did it internally.
Was he? Let me check. I wrote down the names.
Warrant for a burglary, that's
He's
what
a-
it is.
But was that
We
the
gotta
same
get you a
yesterday
copy of that.
for medical?
They didn't revoke your
Okay,
bond
we'll-
on the
we'll-
case that
we'll
you're
just
out
roll
on
it.
bond on.
Yeah, we are.
That's what I'm saying.
Okay, release on your own recognizance.
Who is that, Your Honor? My next case is Bissent.
Yeah, it's Baez.
I apologize.
So are we resetting Baez Centeno then, Your Honor?
We are. I don't know the nature of the medical need. I mean, it might be unreasonable to think we'll have it tomorrow, but I don't know at this point. So we'll call it up again. Is Cecil Green ready?
He refused?
Who?
Did he refuse yesterday as well?
We can address his case.
All right, are you waiving?
Yeah, that's fine. I mean, 2 refusals, Judge, I don't know what he wants.
All right, thank you. There's already been there has not been a probable cause determination yesterday.
I do have a probable cause challenge. It's the same as before, Judge, based off the same case law, i.e., it's alleged my client dropped drugs in front of law enforcement. Didn't leave the area, didn't throw drugs, didn't try to destroy them, eat them.
Attempted tampering, physical evidence. All right, thank you, sir.
Your Honor, it says where I observed Green throw it.
Same difference. I could find a case where a guy drops it on the other side of a fence but do you need that?
Okay. I'm familiar with the issue. I've run across the same thing in delinquency. I again find the facts distinguishable. I will find probable cause and set bond for each count at $1,000.
And he is out on ROR, Your Honor. Will you take any action on that?
That case is not filed on, Your Honor, as of yesterday.
I'm not taking any action today. All right, do we have Mr. Jackson? Good afternoon, Mr. Jackson.
Good afternoon, Judge.
You're currently out on bond, is that right?
I'm out on RR, Your Honor.
Okay. Sir, you have the right to an attorney. I've appointed counsel to represent you today. You have the right to remain silent. We're here because there has been an allegation. Sure. The new charges are robbery with a firearm, armed kidnapping, and aggravated assault with a firearm. Is there any challenge to probable cause? Court will find probable causes counts 1, 2, and 3.
And Your
Court
Honor,
will hear.
this is a PBL. He's not entitled to bond.
Okay.
That's right, yeah.
Not hearing disagreement on counts 1 and 2. The court imposes no bond. Count 3, bond of $10,000.
Your Honor, we would ask for monetary bond. I understand their PBLs. Again, we would just point out that he's bailed in the presumption of innocence. As far as a fact I'm concerned with, or something that I plan on exploring as a defense attorney, is that all of these horrible allegations, this armed kidnapping, this robbery, that they were essentially sexually torturing her, but then drop her off at MCO and say, go along about your day. That doesn't add up to me, and I would ask that the court consider that in setting a bond.
All right, thank you, sir.
We could go downtown and get another.
All right, the court,
Any action on his out on bond, Your Honor? Or out on ROR?
RR is revoked. What was the underlying charge that he was out on? Possession of cocaine?
The only charge that they filed on that out on ROR case is a possession of a firearm by a convicted felon.
Okay. ROR is revoked. Bonding the amount of $1,500.
7-year bond.
Yes, ma'am.
Yeah, we gotta do this one first, but like I said before,
Okay.
don't talk.
All right. Next case, please.
Louis Pagan is outside medical.
What's the first name?
Luis,
Luis, okay, okay. So he is out medical.
So was that the hospital? Okay, you wanna reset him, Joe, within 24 hours, release from hospital?
Is that how we do it? Just
Yeah.
so we don't know? Yeah, I don't know when he might be released. So, yes, ma'am, that makes perfect sense. Thank you. No need to call it tomorrow if he's not going to be here.
So what are we doing, Your Honor?
Oh, sorry.
I'm sorry, reset within 24 hours, release from the hospital.
Thank you.
Say you qualified.
Put more faith in this microphone. All right, would you say your name, please, ma'am?
Nikki Elaine Marilyn Warren,
What's your date of birth?
03/28/94.
We're here, ma'am, because there's been an affidavit filed. You were originally set for initial appearance yesterday.
Yes, sir.
So this was reset. The allegations are possession of cocaine. I've got two different case numbers with that. So we have two individual case numbers, each with a count of possession of cocaine, and then a third case number is possession of drug paraphernalia. Which specifically am I on today?
it's both of them, Your Honor. One of them was a warrant, and then the other was a new law.
What?
And the new law has the paraphernalia attached to it. I
Yes.
believe that's 14787.
All
That's
right, I'll
correct.
find probable cause. Does anyone wish to be heard regarding release status?
Just briefly for the record, Your Honor, same challenge to probable cause as far as the attempted, oh, no, I'm sorry, this isn't. This is just co-defendant on that case. Never mind, withdrawn, Judge, nothing further.
Okay.
Yeah.
You don't qualify for
On
Can't get out.
22-14656, which was reset from yesterday, the bond was set at 500. I'll stay the bond.
Would the court consider PTR in lieu of bond? She doesn't have the financial means to make any sort of bond payment.
I understand that she does not qualify for
She
pretrial
did
release.
not qualify, Your Honor.
Has it been explained to you that $500 doesn't actually mean $500 to get released?
I understand that, but I have no family to come get me. I have nobody. I'm from Arkansas. I don't have nobody to come get me. But I'm.
Me.
Okay. I'm going to keep the bond at $500. But I had a second case, correct?
Yes, Your Honor. 14787 would be the second case.
14787,
It's the new offense, a possession of cocaine and a possession of drug paraphernalia.
right.
Need things to show you're not gonna. Your Honor, she does have a residence. She's staying at you have a bed, right, at the Hope Team?
Whole team is trying to get me into a
Oh.
house, and I'm trying to currently get a job. I've applied for jobs, and they've applied for me apartments here in Orlando. So I'm trying to do better than I was.
Okay. This one was reset from yesterday. Won't count possession. I just addressed that.
Okay, so
Oh, I didn't realize it was over here.
Sorry.
Okay. So I've already ruled on 22 CF 14656. It's bond of $500. On 22 CF 14787, there are 2 counts, possession of cocaine and possession of drug paraphernalia. I'll reset the possession bond again to 500. Possession of paraphernalia, I'll release her on her own recognizance. Is that all of her charges now?
Yes.
Each one's $500.
Mm-hmm. It's there.
You can ask him to
All
put
right.
a bond on that so you get credit.
That would conclude the matter.
Maurice
Right.
Williams is
He
mental health.
understood that and he still set the bond.
Do we, any context, just in general? Okay, reset it for tomorrow. Got Mr. Graham? Have you had a chance to talk to Mr. Graham? Any interaction with him?
What docket's he on?
He's a felony warrant, VOP.
He's
If
refusing
it's a VOP,
today.
we could go forward with it.
He's a VOP.
Correct? Graham? All right. All right, Mr. Graham's appearance has been waived. Counsel is appointed and appears on his behalf. Find that there's probable cause as to the violation of probation. State, am I correct? Well, and the defense, of course.
He's not
Doesn't seem
entitled,
like I have a choice about this. It's no bond.
he's not entitled to bond, Your Honor.
All right. All right, court has no discretion as to that, no bond. All right. Sir, would you say your name, please?
John U. Hamulak,
What's your date of birth?
May 17th, 1974.
Okay. All right, sir, you're entitled to the assistance of counsel. I'm going to appoint a public defender to represent you. You have the right to remain silent. You have a right to a trial in this matter. You have other rights as well. The reason that we're here is that I've received an affidavit that suggests, let me make sure that I'm calling up the new law. You were previously out on trespassing, correct? Is that right?
Yes, sir.
Okay. So what we're dealing with today is possession of an open container of alcohol. I find probable cause as to the matter. Does any party wish to be heard regarding conditions of release?
Your Honor, just that my client is transient. He doesn't have any financial means to post any sort of monetary bond in this case. We'd be asking for non-monetary conditions of release. If that's have him report to the public defender's office every other day or whatever would ease the court's concerns. I see that he doesn't qualify for pretrial release.
All right, anything from the state?
No, Your Honor.
All right, I'm going to grant the relief requested. I'm going to release you, sir, on your own recognizance with the following conditions. All of us have to follow the rules. Whatever our conditions may be in life, there are rules for a reason. So the fact that I'm releasing you doesn't make the charges go away. You've got to deal with them. You suggested reporting to your office?
Or report or call in to check in with the assigned attorney.
I am going to order that. You're to check in with your attorneys, and they, as officers of the court, know that this is your release is contingent on this. It doesn't have to be every other day. Once per week before the close of business Friday. Do you understand that?
And Your Honor, could that be a telephonic check-in?
If it's to an attorney who will take responsibility that I know this case, I know this voice, yes.
Thank you, Judge.
Anything else?
And then are you taking no action on his open case? He's out on ROR? On a
And that is
trespass?
for trespass. Court's taking no action.
Until your case is resolved pretty quickly, but what he just did means if you don't do it, you have to report, okay? Once a week, all right?
All right. We still have this one? Pisa? What's the status of Felix Pisa?
Do you have the booking number for them?
Want to do the resisting, right? The resisting?
They bonded.
So we're left with our two
No, you have two, remember?
pleas, correct?
Right, so I have one after this.
The Berg. The Berg. Remember you said you'd do the $500 bond for you though. Sign there. You're gonna look at it. Witnesses testifying. The proceedings also giving the right to representation.
All right, in the matter of Stacy Hightower, case number 2022 MM8604, correct, Madam Clerk?
Yes.
How do the parties wish to proceed?
Your Honor, may I approach? I have,
All right. What was the offer from the state?
Adjudication of guilt, court calls, credit time served, Your Honor.
And how many days has this individual served thus far? Okay. Mr. Hightower, I'm holding up a form. It's got your name at the top left. It states presumably things you've just gone over with. Is that your signature in the bottom right? Has anybody promised you anything or threatened you to get you to sign this form?
I haven't.
Has your attorney answered your question about this form?
Very clearly.
If you do not enter a plea, you still have a right to trial. Do you understand that you're giving up your right to trial by entering a plea?
Yes, I do.
Is that what you wish to do?
Yes, I do.
Court accepts the plea as knowingly, freely, voluntarily, and willfully given. I will adjudicate sentence this gentleman to time served, specifically 2 days. I will impose court costs. So you have 1 year from today's date to pay those court costs, or alternatively, you have 60 days to report to the clerk to enroll in a payment plan. Do you have any questions? The matter is resolved.
thank you, Your Honor.
You said no contest, Brad?
Yeah. Read that, you understand you want to go to trial?
No, he's still got the form. No, right, you didn't give it to me. So there's Hightower, I think. Thank you, ma'am.
Which one? There are a few cases. No, your court costs will come out to like $200.
Did we recite the amount of costs? I'm used to doing that. in juvenile.
No.
It's okay. We're off the record on that case. But we need to make sure that the amount is annotated.
Your Honor, I have Ray Meralt to stand.
Yes, sir. In the matter of Ray Morales,
Your Honor,
2022 MM 8611.
this is going to be a change of plea, Judge. The agreed disposition in this case is adjudication of guilt, credit time served, court costs, no return. May I approach?
Yes. All right, Madam Clerk, we need to make sure we get the case number on here. Somebody's got to. I'll do it if I need to. All right, how much time has he served on this matter?
How many days? You got 2 days, too?
Yes.
All right. And I will go ahead, court will write in, Division 48-202-2-MM8611.
That was 2 days
Alpha.
credit time served?
Oscar. Say again?
How many days credit time served, Your Honor?
I heard 2.
2, thank you.
Is that acceptable to the state?
That is acceptable, Your Honor.
Sir, at the bottom of this form is a signature. Did you sign this form?
Correct, sir.
Did anyone promise you anything or threaten you to get you to sign this?
Negative, sir.
You know that if you don't enter this plea, you've got a right to a trial, and that when you enter a plea, you're giving up your right to trial. Do you understand that?
Yes, I'm aware of that, sir.
Do you still, did your attorney answer your questions?
Yes, he has.
You-
One question, though. May I have a year from today's date to pay the
Yes.
fines? Or-
That is, yes, that'll be the case.
$273.
All right. I will accept Mr. Morant's plea as knowingly, voluntarily, freely entered. I will adjudicate him guilty, sentence him to time served, which is 2 days. No return to the scene, sir. We're going to come back to that in a second. And impose costs of how much? $273. You've got 1 year from this date to pay that to the clerk of courts, or within 60 days, you can report to the clerk of courts and work with them a payment plan, which may work, you can choose which one works better for you. As far as the no return to the scene, sir, we didn't go to trial on this. I didn't hear evidence on it. Based upon what's alleged, look, people have a right to their private property. People have a right to run their businesses. So take the no return to the scene seriously, please.
Okay, sir.
And with that,
On the case, the maintenance man, and it's a property that's owned by a couple owners. One of the owners was aware that I'm there, the maintenance was aware I'm there. The one owner was not aware I'm there. I'm gonna just retrieve my property and get that guy.
all right, I ordered no return. I will allow you one time to return to retrieve your property if it's on the premises. Merry Christmas.
Thank you.
Is there any other matter before this court?
May the state be excused, Your Honor?
Yeah, trouble.
State's excused.
Have a good day.
All right, court is adjourned.
Yeah.